Item number 1 for delivery order.
For reasons to be mentioned, reasons mentioned in the order, the prayer for bail of the petitioner is hereby rejected. This, yes,
My lord, prayer for motion, listing of a motion AB, my lord, for tomorrow, my lord, supplementary. Will not take much time. my
it
lord.
is less than 7 years.
Yes, yes. I'm deeply obliged.
I'm very clear, my lord. Item number 41, my lord. 41, my lord. This is an IA, my lord, for bail of the appellant is pending, my lord. There is an order for hearing the main appeal, my lord. So my humble prayer, my lord, the matter may be taken away to, my lord, for consideration of IA, more than 8 months in jail custody, my lord.
No, this hearing is of the main appeal or the IA?
My lord, the case is fixed for hearing, my lord, but the IA is pending, my lord, consideration, my lord. So, my lord, since more than 8 months in jail custody, my lord, so, my lord, for consideration on 2 p.m. may be taken up, my lord.
Okay.
Obliged. Obliged.
May I please, Lordship? Lordship, item number 13, my lord. May pass over for the month. My lord.
For the month,
Yes, my lord.
item number
13,
13.
13.
Why?
My lord, my senior is busy in this month, my lord.
Mr. M. Ahmed.
My lord,
What is your name?
M. Ahmed.
M. Ahmed, learned
My lord,
counsel for the petitioner.
interim may continue.
Who prays for an adjournment on the ground of difficulty of his senior, who is the conducting counsel in this case. Considering the ground, have you informed the counsel for respondent number 2?
No,
You
no, my
have-
lord.
You have to inform. There is one
Private party. Private.
private respondent is there.
I will inform, my lord.
Considering the ground, the prayer is allowed. Let this matter be listed after 2 weeks. The interim shall continue till next day.
May I please, Lord? I'd like to mention regarding item number 35 of today's list, Lordship. Here, Lordship, the petitioner was convicted for 2.5 years, Lordship, and his engaged counsel failed to file any application for allowing him to remain on bail. But for that, Lordship, he is in jail, Lordship, for about 3 months, Lordship. So, may I pray, Lordship, this matter will be taken up at 2, Lordship.
That's true, we have already fixed a matter.
2:30, Lordship. 2:30.
No, then it will disturb the list.
Or before
We'll try to take it up.
Or before rising, Lordship.
Obliged.
May I please, your lordship? I beg to mention an IA criminal lordship arising out of a criminal appeal lordship for listing on 8, your lordship. Your lordship, here, your lordship, the accused person is in jail, your lordship.
No, but criminal appeal, there are other senior courts taking up the same roster. You have to mention before the seniors.
One more prayer, your lordship, that is criminal revision petition, your lordship. Last time this court have taken this matter, your lordship. Lordship, the matter was listed for 6 times, your lordship, but it was not heard, your lordship. So, lordship.
Is it part heard?
No, no, lordship.
Then you have to mention before the senior court. The same roster is taken up by other senior courts also.
Lordship, I beg to mention item number 26, my lord. My lord, record has not been received, Lordship. A date may be fixed, my lord, and record may be called for once again, my lord.
26.
26, my lord. Scan copy has not been received.
Heard Mr. M. Rahman, learned counsel for the petitioner who prays for and who submits that the scan copy of the case record of the trial court which was called for has not yet arrived. Stop. Also heard learned Mr. B. Sharma, learned additional public prosecutor. Issue reminder for the scanned copy of the case record. Let this matter be listed again on 26th April.
Obliged, Lordship.
Lordship, I beg to mention for listing of a criminal petition for tomorrow. Admissions.
Senior court,
Justice Robin Fukon is in divisional bench. Therefore, I have been approaching this honorable court.
no,
18 is there.
court number 18.
18 is there.
Obliged.
May I please, your lordship, I beg to mention item number is a 29. My senior engaged counsel, some personal difficulties. Lordship, kindly this matter after verification.
Mr. What is your name?
J Islam,
Mr. J. Islam, learned counsel for, what is the name of your senior?
J Dalon.
J. Islam, who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. Z. Alam. Considering the submissions made by the counsel, the prayer is allowed. Let this matter be listed
He is available there, madam.
before behold. Let this matter be listed on 8th of April. The interim order shall continue till next day.
CDB written, but.
The case diary be retained till next day.
May I please, your lordship? Lord, I beg to mention for listing of a matter, my lord, for motion, my lord. May-
Listing of
Listing of a criminal petition,
No, no, senior basis.
senior court.
15.
obliged.
May I please, your lordship, I beg to mention, bail application for listing tomorrow, lordship.
What is the matter?
Bail application,
Below 7 years or
NDPS.
and it is.
Then there are senior courts taking up special acts. You have to
Court number
mention
18.
before,
Court number.
in your
you will
court number
mention
18.
May I please, your lordship, I beg to mention item number 47, matter may be taken up 2 p.m. today, your lordship.
No. 2 p.m. we have already
Madam.
fixed a matter. We'll
Item number 47.
we'll call it up as per serial.
Madam.
Supplement.
Serially, we'll call it up.
Also, item number 2.
May I please, your lordship? Well, it's 439 application, madam.
Case diary would be required.
Madam, no, madam, it's a different type of a case, madam. It's not under the investigation still. Here is a case, madam, where there are few accused person has been apprehended, madam. In a case, madam, initially it was the 4/1/2023. The FIR was lodged against the petitioner and this other accused person, together 6th accused person. Thereafter, we have been arrested and we got the default bail on 6/4/2023. We got a default bail, my lord, on 6/4/2023. Thereafter, my lord, on 6/1/2024, the informant of that case, my lord, he filed a petition before file an FIR that one of my relative has tried to pursue not to give evidence to the witnesses, my lord. That is his allegation, my lord. So FIR and GD entry has been made to that effect. Thereafter, then they are also filed a cancellation of the bail before the trial court. Up to that, there is no problem, my lord. Now, now the court, the case has not been registered, the FIR was not registered, it was made a GD entry. Maybe it's a cognizable case, but the GD entry, they have made a GD entry, they will start the investigation. But at that point of time, the trial court has assumed the jurisdiction over that matter where the investigation is pending, and he started taking evidence for that purpose, that whether we have tried to pursue the witnesses or not. Okay, he has assumed the jurisdiction, my lord. Now there is an absolute violation of the fundamental rights, my lord. Now what did the trial court did, my lord? He has called the OC of the police station as a witness, court witness. Under which provision, I don't know, my lord. under which jurisdiction that he has started the enquiry of that. Because the enquiry investigation is already pending before the police. Now OC has been called for and his deposition has been recorded. And we have been, when it was fixed for cross-examination, before my cross-examination, my bail has been cancelled.
Okay.
Before my cross-examination. So I couldn't avail my chance even before that of his own. What is that kind of rights, my lord? And only on the basis evidence or OC's evidence, there are other witnesses, the main informant, his deposition not been recorded. And as per the OC statement, there are other witnesses also. That's not been recorded. Only on the basis of the OC's evidence. Now, Lordship kindly see.
Now you are
I am
approaching under 439, not against the cancellation order. You
I'm
have
on
to,
the-
you have
yes.
to challenge
Yes,
cancellation.
because
order.
I'm not, because the 439, we
No,
are, on-
but you have not challenged the cancellation order.
we have not directly, we are not on review.
Then
Because
it remains, then how we can jump over that cancellation? Unless we
cancel,
decide,
the bail, Lordship is definitely can be granted. With that, otherwise that order, we
No.
can challenge it, no doubt. But the bail, Lordship can always on the 439, there is no bar at all. While granting by the Superior Court at this stage, we don't have to challenge that order.
so in this bail application, we may consider whether that cancellation was correct or not. Because unless we decide that whether the cancellation order is legal or not, if it remains, then bail may not be granted. If cancellation,
That is the one proposition, my lord, but my limited understanding, my lord, the 439 does not preclude Lordship to decide regarding the rights of a person who is in the custody without challenging that order. Because suppose in every cases, yes, cancel the bail, no doubt about it. Cancel we are in the custody now. In all cases, in the other cases, when the Sessions Court or the trial court rejects the bail order, when it comes for the 439, we don't go for the cancellation or the rejection. We don't challenge that rejection order.
okay.
We don't challenge that rejection order that has been rejected. So we have come. So 439, my humble understanding.
No, there is a difference between rejection and.
Rejection, definitely,
and-
but we are in this rejection, our bail has been cancelled, we are in the custody. My case is that. Still, well, once upon a time, but my consideration is that the 439, the High Court has a power, even at this stage, to exercise its jurisdiction only for the purpose of the bail. And if the Lordship feels that we have to challenge, that we definitely would like to challenge it.
No, I am not saying that. I am just putting query.
My understanding is that there is no absolute bar
Okay.
that we have to challenge that order and we have to come for the bail.
But while considering your prayer, we have to look into that cancellation order also.
The cancellation is there. Naturally, our
Because you
humble
were
petition only
once,
for the bail at this stage. Cancellation is a different issue, my lord.
Okay.
I'm not on cancellation. But the Lordship exercising the jurisdiction, the under 439 at this stage. Because we are already in the bail. So if that is the Lordship, once then we have to file it, because that will ultimately Lordship indication is that we have to go for the challenging that order. This,
no, what will we consider otherwise? While.
then the Lordship, then we have to file it, then we have to modify this petition or I have to withdraw it.
Perhaps, I don't know. I'm
But-
just putting queries. to you.
So that's my understanding. My understanding is 439 is absolutely, there's no
Because-
bar at all.
Because
Lordship to entertain this, my application.
without going into the merits or the matter in deep, I feel that unless you challenge the if there is a wrong in cancelling your bail,
Yes,
unless you challenge the cancellation order,
then we'll challenge it, my lord. The Lordship is there. Having that view, definitely will, then I'll withdraw my petition, my.
okay. You are paying for withdrawal.
I'll pay for withdrawal.
Heard, Mr. A. M. Bora, learned senior counsel, assisted by Mr. A. I. Majumdar, learned counsel for the petitioner. Praise for allowing the petitioner to withdraw the instant bail application. I'm making no other observation. The prayer is allowed.
Published.
Item 3.
May it please your lordship, the 439 application, my lord. These are charge sheeted case, my lord. The lordship may turn to page 15 for a once, my lord.
POXO,
No, my lord. My lord, here,
7-1.
Yes, my lord, 571 days, my lord. And in this case, earlier charges were framed, but when it was found that another,
NDPS case,
yes, my lord, and special NDPS case.
571 is how many, in years it will come to 1 year?
My lord, it stands at 1 year, 6 months, 24 days, my lord.
Okay, we'll call for the scan copy.
Madam.
Heard Mr. M.A. Ahmed, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. Let the scan copy of case record of special NDPS case number 133/2022 be called for from the Court of Learned Special Judge Karimganj. The registry to take steps for requisitioning the scan copy. Let this case be listed again on 30th of April.
Maybe little argument.
No, no, NDPS.
26.
26 April.
26th of April.
26 April.
Item 42 from supplementary list.
May it please your lordship, yesterday also the case was listed, lordship. So I have gone through the provisions, lordship, kindly produce section 439, lordship.
No, no,
For once, lordship, there is one thing to look out for, lordship, once, lordship, I have judgment also, lordship.
okay. That he is in custody.
Lordship,
And 437,
439,
Yeah.
lordship,
Hmm.
kindly produce section 439, lordship. It's
No,
special,
that provision we have discussed yesterday, that
No.
this court has power.
no, lordship, there is one specific here.
Okay, okay.
437 special powers of High Court or Court of Session regarding bail, lordship. A, that any person accused of an offence and in custody be released on bail if the offence is of nature specified in subsection 3 of section 437, lordship. Subsection 3 of section 437. Now kindly peruse subsection 3 of section 437, lordship.
No, that was not the query.
Lordship,
Oh.
here subsection,
Query was that power is there.
Lordship.
There was no dispute that High Court does not have the power.
lordship.
Query was why you have ignored 437.
No,
Why?
one section is there 420, lordship, and their punishment is punishable with imprisonment which may extend to 7 years, lordship.
Yes,
And there is a specific 437(3) punishable with imprisonment which may extend to 7 years, lordship. 420 is there, lordship. Only peruse 437(3), lordship. When a person accused or suspected of the commission of an offence punishable with imprisonment which may extend to 7 years
yes,
or more,
yes.
or of an offence under chapter 6, chapter 16 and chapter 17 of the IPC, lordship. So here it is specific that with punishable with imprisonment which
No,
may
no,
extend
what
to
you
7
want to
years.
say? 437 also you can, the court may grant you bail.
But 439(3) is specific here, lord. 437(3) is specific there, lordship.
No,
And-
439,
In 439, lordship, 439A, lordship, there is a specific about subsection 3 of section 437, lordship. We may approach, lordship,
no, which provision? 439?
439A, lordship.
No, that relates to only power to impose condition,
Lordship, that is there,
not regarding power to grant bail is there.
lordship.
439A speaks about that conditions which are mentioned in 437A
Lord.
can be imposed by the,
Lordship,
only to that aspect.
and
My
maximum,
query was different. My query was when 437 is there. 439 is also there.
Lordship,
439 Sessions Court and High Court
High
has
Court.
concurrent jurisdiction.
Lordship,
So you can come to either Sessions Court or High Court.
Lordship.
But why you have jumped 437? What made you
Lordship,
to
number,
approach directly to High Court?
Lordship, number
Why
one,
this court should exercise its discretionary power?
Lordship, number one is section 420 is attracted here, and number two,
Now
Lordship,
for 420, 437 relief is also available.
Lordship,
Then
Lordship, since 420 is attracted there, we have approached this honorable court, and secondly, Lordship, one judgment is also there, Lordship.
what judgment?
Lordship, para number 8, Lordship.
What it says? Vera?
Para 8, Lordship. Para 8, Lordship, page number 7, Lordship. Second paragraph, Lordship. Page number 7. Lordship.
Yes.
From obviously, Lordship. Para number 7, para number 2, Lordship. Have you got it, Lordship?
Page number?
Page number 7, Lordship.
Yes.
Para number 8, part 2, Lordship.
Okay.
The CRPC severely curtails the power of the magistrate while leaving that of the Court of Sessions and the High Court untouched and unfettered. It appears to us that this is the only logical conclusion that can be arrived at the conjoint considerations of section 437 and 439 of the CRPC. Obviously, in order to complete the picture so far as concerns the power and limitations thereto of the Court of Sessions. Lordship, have you got it?
Yes.
Obviously, in order to complete the picture so far as concerns the powers and limitations thereto of the Court of Session and the High Court, section 439 would have to be carefully considered. And when this is done, it will at once be evident that the CRPC has placed an embargo against granting relief to an accused if he is not in custody. It seems to us that any persisting ambivalence or doubt stands dispelled by the proviso to this section, which mandates only that the public prosecutor should be put in notice. We have not found any provision in the CRPC or elsewhere, nor have any been brought to our ken curtailing the power of either of the superior courts to entertain and decide pleas for bail, Lordship.
No, that I am
So
mentioning.
there is no,
That I am stating since yesterday that
Lord.
there is no bar.
Lordship.
But why should I entertain your petition when you have not approached the magistrate court under section 437? What is the ground?
Lordship, next paragraph, Lordship.
Yes.
Next page, Lordship. Next page, Lordship, page number 8, Lordship. Some salient features of these provisions are that whilst section 437 contemplates that a person has to be accused or suspect of a non-bailable offense and consequently arrested or detained without warrant, section 439 empowers the session court or high court to grant bail if such a person is in custody. The difference of language manifests the sublime differentiation in the two provisions, and therefore there is no justification in giving the word custody the same or closely
No,
similar
it-
meaning and consent
no,
of arrest or detention.
Mr. Board. What is your name?
P. Bordle, Lordship.
Mr. Bordole. That is not my query.
Lordship.
I am clear that 439 is, this court has power.
Lordship.
And this, if the accused is in custody, this
Lordship.
court can exercise
Lordship.
power under section 439.
Lordship.
But you have on the, immediately after your arrest, you have approached this court.
Lordship.
You could have gone to Supreme Court also, saying that Supreme Court also has power.
Lordship.
My query is when magistrate court was available at Nagaon, nearer to the accused, why you have,
Lordship, there are two things. Specifically, this judgment states that there is no bar in approaching the section 439. And number two, Lordship, 420 is also there, Lordship. Since the punishment is extended up to 7 years, therefore, for these only two causes, they have approached this honorable court, Lordship.
okay, heard Mr. P. Bordole, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Call for the case diary.
Lordship, may I submit, Lordship? One thing, Lordship. Lordship, one thing, on merit, Lordship. Already.
No, now unless I peruse the case diary, I will not be able to.
Lordship, the other accused have been granted bail, Lordship. on
By
Monday,
which court?
By Nagaon Magistrate Court. Lordship.
So you have to either approach there or wait for the case diary.
Then I may be allowed to withdraw.
Yes. On request, heard Mr. P. Bordole, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This case is dismissed on withdrawal.
Lordship. Obliged.
Item 43.
And in this case, my lord, I have been in custody since 27 to 2023. In a special NTPS case number 19 of 2020, pending before the session judge Karimganj.
Since
27 to 2023. Second,
we are, it is less than,
1 year, 1 month, 6 days today.
what is your ground?
Ground my lord, till today, my lord, no PW is examined. And on delay of trial, my lord, I am seeking bail. And a number of occasions, my lord, there in this footing, my lord,
But for in 1 year, 1 month, you will not get bail.
my lord, in some other cases, my lord.
Show any case where.
Yes, my lord, I have annexed, my lord. I have annexed.
My lord, it depends
My lord,
upon the facts and circumstances of the case, my
No,
lord. Why
let me
is
see.
there
My
is a
lord,
delay, my
kindly
lord?
Page 31, my lord.
It is not time bound, my lord, that 1 year, 6 months, the court will allow, my lord.
Kindly see page 31.
Considering the facts and circumstances, it is also necessary,
Heard
my lord.
Mr.
Page R. Chaudhary.
H.
R. Chaudhary.
H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Additional public prosecutor. Call for the scanned copy of the record of special NDPS case number 19/2023 from the court of
LCR along with CD, my lord.
learned Special Judge Karimganj, along with the scanned copy of the case diary of
LCR along with
Karimganj PS case number 166/2023. The registry to take steps for requisitioning the aforesaid scanned copies. Let this case be listed on 30th of April.
Item number 6.
May it please your lordship, 438 bail application. FIR is space 10, lordship. Lordship, I am not naming the FIR, lordship. Lordship, 41 SCRPC has been served to the petitioner, lordship.
Yes.
Lordship, my name is not in the FIR. The specific allegation against the Niranjan Bormon, lordship. Kindly see the page 10, lordship.
You are not named in the affair.
No,
Then
no.
why are you apprehending?
Lordship, 41 SCRPC notice has been served to the petitioner, lordship. Only, lordship.
So you comply with 41A. Why? Merely by 41A has been issued only because police do not intend to arrest you. Therefore, that notice has been issued.
Lordship, a non-bailable section is there, lordship, which I may be arrested, lordship.
No, if you are not involved, you are not named. What is the basis of your apprehension? Merely 41A notice has been issued.
Lordship, I have annex lordship, annex page 17 lordship.
But 41A notice is the procedure which has to be adopted when the police thinks that you need not to be arrested.
Lordship, protect me, I'll appear before the IO and
And where is the 41A notice?
lordship, page 17 lordship.
Already gone, my lord, 22/3.
That date is lapsed.
My lord.
Lordship.
Therefore, you may be apprehending. You have to submit. Heard, Mr. What is your name?
M. Alam lordship.
Heard, Mr. M. Alam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mrinal Bormon, who is apprehending his arrest in connection with Mushalpur PS case number 25/2024. The gist of accusation in this case is that one Rupali Bala Roy, WPC 96/96 of APB headquarters, Soraimari, Baksa, had leveled certain allegations against one Lasnayak Niranjan Burman, of cheating the first informant after giving her promise to get married. Learned counsel for the petitioner has submitted that the petitioner is nowhere connected with the offense alleged in the FIR, and he is also not named in the FIR. However, he has received a notice under section 41A of the CRPC from the issued by the Deputy Superintendent of Police Baksa in connection with the case which was registered on the basis of the said FIR. And in the said notice, the date for his appearance was mentioned as 22/3/2024. However, why you could not appear before?
Violated the.
Why you have not appeared?
Also, due to some personal difficulties, he could not
Have
appear.
you mentioned in the? But due to some personal difficulty, he could not appear before the police in pursuant to the said 41A notice under CRPC, and therefore he is apprehending that if he appears now, he may be arrested. Considering the submissions made by learned counsel for the petitioner, this anticipatory bail application is disposed of with a direction that the petitioner shall appear before the investigating officer of Mushalpur PS case number 25/2024 within a period of 10 days from the date of this order, and shall cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Mushalpur PS case number 25/2024, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Number one.
One line, my lord, my submission is that CD may be called for determination of the rule.
Though learned counsel for the petitioner উপর দিকে, learned additional public prosecutor submitted that case diary may be called for.
To find out his role, what role he has played.
With this observation, this anticipatory bail application is hereby disposed of.
Item 7.
Four 438 application lordship, FIR lordship will find page 8. I'm not naming the FIR. The allegation in the FIR is that the informant's bike was stolen and accordingly he lodged an FIR. And in the present case, lordship, 2 persons were arrested. One lordship Ainal Haq and one Paris D. Sagma. And Ainal Haq is one of my friend lordship. So I also apprehending arrest because he was arrested. Therefore, I filed one bail application before the sessions court lordship. And when I filed, interim was granted, but there was some communication gap between the advocate and the counselor and the accused lordship. So he could not appear, and subsequently, for his default lordship, his bail application was rejected.
Anticipated bail.
Yes, lordship. Lordship will find page 14. And relevant portion of lordship will find
Page 15, my lord. Sufficient incriminating material exists against the Rafiqul Islam, my lord.
What is your name?
Rafiqul Islam, my lord.
That's sufficient, your lordship will find that that paragraph I am reading, lordship. The fact of the case, the facts of the case have been narrated in the order dated 8/2/2024. The CD reveals that sufficient incriminating materials exist against the petitioner Rafiqul Islam and custodial election of the accused petitioner will be required for recovery of many stolen bikes, some other bikes, not regarding this bike. This bike is already recovered. I have stated in my petition, lordship. Regarding other bikes, there is no.
Then he is habitual, my lord.
The
If
CD
some involved in some other
The
also.
CD also reveals that the accused has not appeared before the IO within 7 days of the order dated remand as directed. So mainly on that ground also. I will appear also, I will disclose
No, but
everything.
why you defaulted earlier?
Because also there was some communication gap. with
Where
the-
have you mentioned?
Yes, I have stated in my petition also, lordship will find.
Let him appear. We'll call for the case then. Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Rafiqul Islam, who is apprehending his arrest in connection with Hatigaon PS case number 353/2023 under section 379 of the Indian Penal Code. The accusation in this case is that on 27/10/2023, one Sheikh Humayun Khalid had lodged an FIR before the officer in charge of Hatigaon Police Station wherein he has reported that his Yamaha bike bearing registration number AS01ET 7517 has been stolen away. Learned counsel for the petitioner has submitted that the petitioner has not been named in the FIR. However, 2 persons were arrested in connection with this case, namely Ainal. What is the name of the arrested person?
That's Ainal Haq.
Ainal Haq and
Paris D. Sangma.
Paris
D. Sangma.
D. Sangma. And the arrested person Ainal Haq is the friend of the present petitioner, and therefore he apprehended that he may also be arrested. Stop. The petitioner had earlier approached the court of learned Sessions Judge Kamrup, Sessions Judge number 3, Kamrup Metro, Guwahati, praying for anticipatory bail, and he was given interim relief and was allowed to go on interim bail with a direction that he shall appear before the investigating officer of Hatigao PS case number 353/2023 within a period of 7 days from the date of the said order. However, he could not appear before the investigating officer, and thereafter by order dated 22/2/2024 passed in AB case number 47/24, learned additional session judge FTC number 3 Kamrup Metro had rejected the prayer for anticipatory bail. Learned counsel for the petitioner has submitted that the petitioner could not appear before the investigating officer as was directed by learned additional session judge within bracket FTC number 3, as there was some communication gap between the counsel who conducted between his counsel and the petitioner. It is also submitted by from where we will find out that vehicle has been recovered.
That paragraph 4, Lordship. That is their statement, my lord. Paragraph 4, last 3 lines.
But apart from your statement,
Apart from my son, there is
it is also submitted by learned counsel for the petitioner that the stolen vehicle has already been recovered. Paragraph 4.
Paragraph 4, last 2 lines. 2, 3.
From whom it was recovered?
that I have to.
Stolen vehicle has already been recovered. Stop. Learned counsel for the petitioner has submitted that though due to communication gap, he could not appear before the investigating officer. However, he is ready to cooperate with the investigation. On the other hand, learned additional public prosecutor submitted that in the rejection order by the learned additional session judge, it is mentioned that there are incriminating materials against the present petitioner, and the interrogation of the present petitioner may be necessary for recovery of other stolen bikes. Stop. He has also submitted that perusal of the case diary would be necessary for. Stop. As it appears that the observation of learned additional session judge number 3 pertains to requirement of custodial interrogation of the present petitioner only for recovery of other stolen bikes, about which there is no mention in the FIR dated 27/10/2023. Stop. The said FIR pertains only to the theft of motorcycle bearing registration number AS01ET/AS01ET 7517, which is stated to be already recovered. Stop. Perusal of the case diary would be necessary, hence call for the case diary. However, considering the submissions made by learned counsel for the petitioner, as well as considering the facts stated herein before, the petitioner is directed to appear before the investigating officer of Hattigaon PS case number 353/2023. And within 10 days from the date of this order and cooperate with the investigating officer. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Hattigaon PS case number 353/2023, he shall be allowed to go on interim and bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions, condition number 1 and 2. Let this case be listed again on 2nd of May.
Item 8.
May it please your lordship. 438 application, petitioner Yashir Islam, your lordship. FIR is lordship. Page 17, your lordship.
392. Page, FIR is that page?
17, particular 17, your no? May I read the FIR lordship?
Yes.
Within the language of the FIR, your lordship, there are no section of 392, your honor. It is a purely case of extortion. My name does not appear in the FIR, your lordship.
Okay.
I am a victim of the circumstance. I am a student, BA first year, your lordship. Allegation against the two-person lordship. Already Manaspatim Deka recovered 2 mobile. 1 mobile recovered from the Manaspatim Deka, another from the accused Abu Faris. Abu Faris. Already matter is solved, your lordship. But my when police came to my house, lordship, I approached before the additional district judge, Romia, lordship. My bail period is rejected, your lordship.
Anticipatory bail. Anticipatory bail.
Lordship.
Why?
The ground that
Where is
lordship
the rejection order?
Huh?
Rejection order?
Rejection, Nexa C.
19, my lord, page 19.
Page 19, lordship. The rejection order is totally lordship contradictory, self-contradictory, lordship. Your lordship will find.
What was the allegation? FIR?
FIR, lordship. FIR, Honmanpura Bindo Niben is a moi Nippon Sumua, Soharaigat Sumua Para Gao Nibaki Tota, Sedofax Delivery Partners Delivery Boy Home. Azi 29/8 তারিখে দিনৰ প্ৰায় 11 বজাত নিম্ন উল্লেখিত বিৱৰণৰ মোবাইল ফোন দুটা ডেলিভাৰী কৰিবলৈ বেজাৰা ইউকে বেংকৰ সন্মুখৰ গ্ৰাহকৰ মোবাইল নম্বৰ ইমানিমৰ নম্বৰত মই যোগাযোগ কৰো তেতিয়া গ্ৰাহকে ইমান নম্বৰ গৰাকীয়ে মোৰ লগত মোবাইল ফোন যোগাযোগ হৈ বেজাৰা ইউকে বেংকৰ সন্মুখত এখন কলা ৰঙৰ কেটিএম ডিউক মটৰচাইকেল দুজন যুৱক মোৰ ওচৰত উপস্থিত হয় আৰু মোবাইল দুটাৰ মূল্য জিপে কৰি দিম বুলি মোৰ স্কেনাৰ বিচাৰে মই মোৰ মোবাইল স্কেনাৰ উলিয়াব ধৰোতে যুৱক দুজনে মোবাইল ফোন দুটা মুহূৰ্ততে কাঢ়ি লৈ পলায়ন কৰে লগে লগে যুৱক দুজনৰ পিছ লও যদিও যুৱক দুজন খালমাৰা বুঢ়ী পথাৰৰ উধাও হয় that is the allegation to person lordship the phone number which mentioned in the FIR that is not mine lordship two already 2 person that is Manaspatim Deka accused Manaspatim Deka recovered 1 mobile another mobile from Abu Faris lordship. I am not entangled with that case lordship.
No, but the name of these Manaspratim and Abu.
That is reflect lordship in the judgment in the order lordship.
Orders. Okay.
In the 21 page lordship. 21 page number. From top lordship 1, 2, 3, 4, 5. 21 pages lordship. That is case diary also reveals that 1 plus mobile handset has been recovered and seized from the possession of Manaspatim Deka of Sanmari Guwahati as per statement of the accused Abu Faris Razi. He sold 1 plus 10 Pro 5 FG mobile phone to one doctor of Mission Sariali, which is yet to be recovered.
two mobile lordship, already investigation is completed. One recovered from Manaspatim, another, the accused Abu sold to the doctor of Mission Sariali lordship. And moreover, there is no any ingredients 392. Simple, there is no put any fear, there is no any restraint, there is no any heart, there is no any. I'm a student lordship. BA first year lordship. First sentence.
What is your name?
My name is lordship, Yashir Islam lordship. Yashir Islam. Students of BA first sem, Mongol College lordship.
No, but you have called.
No. That is not my mobile number lordship.
No, no. Case diary reveals that
My lord.
Abu Firdaus and his associate, namely Yasir Islam, called the delivery boy to them.
How my name is come lordship? Manas recover one Manaputin Deka, another from Sir lordship, from Abu Faris lordship. I mean victims of circumstance lordship.
Lordship, may kindly peruse the page 21, my lord. Here is also shows
Case
that, my
diary
lord.
would be required.
My lord, case diary shows sufficient incremental material against the Yasir Islam, my lord. Present petition.
What materials lordship?
No,
No,
What
no,
materials
once
lordship?
the court has,
Incriminating materials lordship. What materials lordship?
we have
That was
to-
not reflected.
we have to peruse.
Lordship, I am ready to cooperate with the, I am ready to cooperate with the investigating authority
No,
lordship.
we are fixing short date,
In the meantime, lordship, I may protect, I am a student lordship.
not now, because the observation of the sessions court
Court
is
meeting.
that.
Sir, lordship,
Now, whether sessions court observation was based on materials in the case diary or not, that we have to examine. Because sessions court has said that custodial detention is necessary. Now, is it necessary or not?
that is only 392 lordship. If the case was registered under section 384, there is nothing lordship. There is no materials of the 392 lordship. Lordship is no better than me lordship. Whether there is any ingredients of the 392.
When in, you can bring the case diary.
My lord, from Bayata side, my lord.
Moreover, lordship,
Ninth, my lord. Ninth, my lord.
self-contradictory lordship order. The case is brief that accused Abu Fardas Razi Rahul gave online order for purchasing two OnePlus mobile phones through Flipkart. Order page 1 lordship. The case is brief that accused Abu Fardas Razi Rahul gave online order for purchasing 2+ mobile phone through Flipkart. Accordingly, on 29/8/23, informant Nipon Soma, who is the delivery boy. It is clearly reflected in the first page, lordship, in order, lordship.
No, we are fixing a short date.
I'm a student, lordship.
Let us,
Considering my position, lordship, if there is any adverse, then my interim will be reject, lordship.
not now. Because sessions court has rejected. We are fixing a short date on 8.
Ninth, my lord. Bayata side.
Bring it
Ninth.
on 8.
Ninth, my lord.
9.
9. Heard Mr. D.K. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Considering the allegations made in the FIR, as well as in view of the rejection order of the learned additional session judge, perusal of the case diary would be necessary to consider the anticipatory bail application of the present petitioner. Hence, call for the case diary. Fixing 9
April. lordship.
April for case diary.
Moreover, lordship, in this case, there is no 392 materials, lordship.
On 9th, we will consider.
All right.
Item 9.
9 will be taken after some of my scenario.
Item 10.
Made 438 application, my lord. FRE space 12, my lord. I am Raju Burman, my lord.
Raju Burman.
Page 12, my lord.
Yes.
May I read, my lord? It is to inform that you, Mr. Sharma Ramsiari of Burma, proprietor of MS SMR Enterprise, address second floor Santi Enclave, Dwarkanagar near Downtown Hospital, Namkar, Sorumotaria so and so, mobile number so and so, is illegally trespassing and using my depot without my consent at village so and so, district Baksa, pertaining license to so and so, along with Mr. Dulal Burman, alias Dulal Chandra Burman, mobile number so and so, permanent address, Brahmapara, Odlabari, PSM district, Jalpaiguri, and temporarily address care of Raju Burman, my lord. And so, along with Mr. Mohandas of Simla district, Baksa. That sir, Mr. Sharma Ramsiari is a business partner of Dulal Burman, and Mr. Dulal Burman is the same person who, with malafide intention, has cheated our payment from Lakhi Cement. The supporting
Now, why
documents-
are you apprehending
Yes, my lord. Dulal Burman is rented.
your tenant?
Yes, my lord.
But there is no allegation against you.
Yes, my lord. But my lord, police is my lord harassing me, my lord. That is my lord. And Dulal Burman already granted bail this honorable court, my lord. Page 15, my lord. In interim bail, and case diary was fixed on 22 April, my lord. Page 15.
Heard Mr.
M. Kolita.
M. Kolita, learned counsel for the petitioner, also heard Mr. V. Sharma, learned additional public prosecutor.
Here proceed.
This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Raju Burman, who is apprehending his arrest in connection with Simla PS case number 13/2024 under section 447/420 of the Indian Penal Code. The gist of accusation is that one Manoranjan Doimari has lodged an FIR on 20 February 2024 again before the officer in charge of Simla Police Station, inter alia, alleging that one Sharma Ramsiari and one Dulal Burman have illegally trespassed and using his depot without his consent. It is submitted by learned counsel for the petitioner that no allegation against the present petitioner has been made in the FIR. However, merely because the address of the co-accused Dulal Burman has been shown as a tenant of the present petitioner, the police is harassing the present petitioner. It is also submitted by learned counsel for the petitioner that in the meanwhile, a coordinate bench of this court has already granted interim protection to the accused Dulal Burman in AB case number 724/2024 by order dated 18/3/2024. Stop. Learned counsel for the petitioner has submitted that the petitioner shall cooperate in the investigation. We can dispose it off.
My lord.
There is no allegation against him.
My lord, this is the payment parts, my lord. My submission may be recorded, my lord.
Learned
If there is any involvement.
learned
regarding-
counsel for the petitioner, learned additional public prosecutor submits that the result of the case diary would be necessary for consideration of the instant bail application. However, as it appears that no specific allegation has been made against the present petitioner, the petitioner Raju Burman is hereby directed to appear before the investigating officer of Simla PS case number 13 of 2024 and within 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Simla PS case number 13/2024, the above named accused person shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. With following conditions, condition number 1 and 2. With above observation, this anticipatory bail application is hereby disposed of.
Lordship.
Bail hearing be item number 14.
Wait, please, your lordship. Lordship may kindly adjourn the matter for the day. May lordship may fix it for on Monday for hearing.
Heard, Miss
And Sultana.
N. Sultana, learned counsel for the petitioner, who prays for. Why are you praying for adjournment?
Lordship, my senior is not well. She was
Okay.
ill. She had to leave.
Prays for an adjournment on the ground that the conducting counsel, Miss S.K. Nargis, is not well. Considering the ground, the prayer is allowed. Let this case be listed again on
Monday, lordship.
8th of April.
Right.
Item 15.
April. Lordship, 439 bail petition, Lordship. Case is already charge sheeted, Lordship, but charge yet not framed, Lordship. Petitioner are in custody for last more than 471 days. Lordship, kindly have a look at
How many days?
Lordship.
For how many days?
And Lordship, 471 days.
Okay,
Till
what,
date, Lordship, charge not framed. One thing. Second thing, Lordship, while the article was seized, contraband was seized on Lordship 2020, 22.
okay,
And it was placed before the learned concerned magistrate the next day, that is on 20. And sample was, though not in presence of the magistrate, only certificate of the magistrate was taken, Lordship. So it was not done in conformity with section 52A of the NDPS Act, Lordship. And it was, there is an inordinate delay. It was seized on 19th and certificate was obtained on 20th, Lordship.
20th,
On the
next
next day. On the
next
next
day
day.
is not inordinate delay.
Lordship, more than 24 hours, it was seized on 19th, about 9 a.m. Lordship. More than 24 hours. And another thing,
Oh,
Lordship.
that may not help you.
Lordship, but main Lordship, inventory and
sampling was-
sample was done not in presence of the magistrate, Lordship. It was done by the IO himself
Where?
and certificate when it was not stated. It was seized and sent in the Lordship police station. And thereafter, in the next day, sample was prepared and only certificate obtained from the learned magistrate, Lordship. Lordship, kindly have a look at the order passed by the learned magistrate. Record is LCR is there, Lordship. Order dated 2012-2022.
Order dated
2012-2022.
order is not there.
Lordship, in the case record,
The first order is 26-12.
not that, Lordship. It is in the second file, Lordship.
Flag it.
May I have?
Flag it. Yes. Yes, Mr.
Lordship, kindly have a look. It was drawn earlier and sample was drawn earlier and only certificate was obtained.
No, from where you are saying that it was drawn earlier?
Lordship, it is order reflected that it was not prepared. Dear Lordship,
No,
only
it is for,
certificate.
order says that in the prayer for drawing of representative sample of the seized.
It was that-
You read it. Video.
Lordship, last para, Lordship.
You read it.
Down.
Read
May I
it.
read? IO has also produced the photograph seized article for seen before this court today, which is duly seen and seizure list of the seized substances marked as MR such and such. Lordship, it is not in, from this it can be inferred that it was not Lordship done in presence of the learned majesty. That is in violation of Lordship Mohanlal, Union of India versus Mohanlal's case, Lordship. Para 17 of the Mohanlal case is clearly stated that it should be done in presence of the majesty.
No, but from that sentence, how can we find out that it was?
Lordship, it has produced photograph and seized article for seen before this court today.
Yes. But in the first paragraph, the prayer
And
is
which
for,
is duly seen. So my submission, Lordship, will appreciate.
No. Yes, what else is your submission?
And another second submission, Lordship, same pool was in the police Malkana for more than 4 months. And thereafter it was sent to the FSL authority. It was sent, Lordship, on 11/4/2023. And report was received on 29/5/2023. That is also illegal, Lordship. And another aspect I cannot substantiate, that's why I am not submitting on that point, Lordship. I am not able to substantiate. And Lordship, moreover, till date, charge is not same. And another accused is also Lordship, till to be arrested, Lordship. So there is no chance of bringing charge very soon, Lordship. Considering all this aspect, Lordship.
My lord, there are 4 accused persons, lordship. 4 were, my lord, together, lordship. They were together, but lordship, 1 accused person is fled away, lordship. That is why the other 3 accused persons were apprehended. Now, lordship, search is submitted, lordship. This is a commercial quantity, and due to non-appearance of this,
What was the seizure?
my lord, seizure it's a heroin, lordship. 739 grams, lordship, heroin. 739 gram heroin.
Okay.
Now, lordship, due to non-appearance of the accused number 4, lordship, the trial could not proceed, my lord. NBW has been issued, my lord, against this person, lordship.
But then what will happen to these accused?
My lord, without appearance of the other accused person, the trial could not,
Otherwise,
my lord, proceed,
after
my
some
lord.
time, they will get the benefit of prolonged incarceration. They cannot be detained for unlimited period
Lord,
without
that's
trial.
true, lordship. But, my lord, what is the definition of prolonged incarceration, lordship?
That court will
Prolonged
decide.
incarceration is means, lordship, suppose assuming there is, my lord, such as in claim, witnesses are not turned up, lordship, in spite of issuing, my lord, issuing, my
No,
lord, summons or my
Prolonged
lord, warrant.
incarceration means for whatsoever reason,
My lord,
the accused is facing trial in custody,
my lord.
and that detention is, in the considered opinion of the court, is long enough to allow him to go on bail.
Then, my
Here,
lord, the rigors of 37 will also come, lordship, then. Lordship will also have to draw satisfaction under section 37 of the my lord, NDPS Act, lordship. That is true, lordship. Prolonged incarceration will be
No,
come,
here
definitely will
he's-
come, lord. But at the same time, lord, 37
471 days.
Lordship, 37 will go. As the prosecution failed to comply with the requirement of
No,
section 52.
no,
A.
lordship. At this stage, lordship, it is for the appearance of the accused number 4, lordship. Non-bailable warrant of arrest has been issued against him, lordship. So as per the last order, lordship, the accused person has not been appeared, lordship. Now it is not the fault of the matter of prosecution, lordship.
But it is also not the fault of the accused.
Yes, but maybe, lordship, but my lord, if lordship consider the, my lord, prolonged incarceration, then lordship will also have to consider the section 37 of the NDPS Act, lordship. Lordship will have to draw satisfaction there at the event of granting them bail, my lord.
471 days turns out to, in years, how many?
Lordship, it is 1 year. Lordship, 3 months, more than 3 months.
My lord, FIR laws, my lord,
3 months to
FIR
1
laws
year.
on 2012-2022, lordship, FIR laws. And my lord, the searches submitted, lordship.
Mr. L.R. Majumdar, learned counsel for the petitioner. Also heard Mr. R.R.
After 4 months, searches submitted, lordship.
After 4 months.
After 4 months of the closing of the
Also heard Mr. R.J. Borua, learned counsel for learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Jamir Uddin, who is detained behind the bars since 19/12/2022, within bracket, for last 471 days. No, what are your authorities in the support of prolonged incarceration?
Wrong lordship.
What authorities are-
Lordship. Three cases, lordship.
Number
One, Ravi Prakash versus State of Odisha, lordship. Another lordship,
Ravi Prakash is 7 years
lordship,
behind the bars.
lordship. But in that case, lordship,
Though
charge free. In this case,
observation is there that the accused may get benefit of prolonged incarceration, but in that case, the
lordship, that is true. And another lordship, Nitish Adhikari,
what was the time?
it was 1 year, 7 months, lordship.
That is also you have not.
Lordship,
attained.
and another lordship, 1 year, 6 months, Shariful Islam, lordship, sorry. 1 year, 6 months,
Shariful Islam.
lordship.
You give the citation.
Lordship.
You will not get benefit of these three because in these three cases, the petitioners were detained for a longer period of time. What was the last time?
But in this case, lordship, there will be no possibility of lordship framing charge and commencement of the trial, lordship. That aspect may be considered.
Okay.
Another person is still absconding, and lordship, second aspect, lordship, seized item was sent for FPSL examination after
No, that has to be considered during trial. That
lordship and
delay in the Malkhana.
52A also.
52A, it appears that it has been complied with. What was?
And
the
lordship,
question?
Regarding
leave it
52,
here,
Lordship,
Lordship.
he can place all the material at the time of premium search, my lord. Now, Lordship, the trial has not yet commenced, Lordship.
What was the
At
last
this
line?
stage, my lord, I am opposing, my lord.
$471 days. The accusation in this case is that about 739 grams of heroin was seized from the possession of four accused persons.
Lordship.
4 accused persons, including the present petitioner. And on 20/12/2022, one Nando Kumar Singha, SI of police, had lodged an FIR to that effect before the officer in charge of No, Nanda Kumar, instead of Nanda Kumar Sinha, SI Neelam Jyotis Nath, officer in charge of Ramakrishna Nagar PS. On receipt of the said FIR, Ramakrishna Nagar PS case number 165/2022 was registered under section 21C/25/29 of the Indian Penal Code. An investigation was initiated. Stop. Ultimately, on completion of the investigation, charge sheet was laid against 4 numbers of accused persons, including the present petitioner, on 30/4/2023 under section. Charge sheet was laid under 21B.
Lordship. But that is typographic, I think
Okay.
typographic mistake, Lordship.
21B/25/20.
More than 10 years.
21C/25/29 of the NDPS Act. It is submitted by learned counsel for the petitioner that the petitioner has been detained behind the bars since last 471 days and though the charge sheet was laid when the charge sheet was laid on 30/4/2023, till now charges are yet to be framed by the trial court. It is also submitted that as one of the accused persons named in the FIR is absconding and non-bailable warrant of arrest have been issued against him, there is no possibility of initiation of trial in the near future, and therefore, on the ground of prolonged incarceration, the petitioner is entitled to get bail. In support of his submissions, learned counsel for the petitioner has cited following rulings of the Apex Court of India. Number 1, Ravi Prakash versus State of Orissa, reported in 2023 0 Supreme within bracket SC 707. Number 2, Nitish Adhikari versus Nitish Adhikari alias Bapon versus State of West Bengal within bracket CRM within bracket NDPS number 442/2022. Order dated 1/8/2022. And Sariful is number 3, Sariful Islam alias Sarif versus State of West Bengal within bracket CRM within bracket NDPS number 299/2022. Order dated 4/8/2022. Learned counsel for the petitioner has also submitted that in this case, the prosecution side has not complied with the mandate of section 52A of the NDPS Act, 1985, as from the order sheet dated 20/12/2022, passed in RK Nagar PS case number 165/22. It appears that the samples of the seized contraband were not drawn in presence of the judicial magistrate. Learned counsel for the petitioner has also submitted that the seized contraband, the sample drawn of the seized contraband was kept in police Malkhana for about 4 months before sending the same for forensic examination to the forensic laboratory Guwahati, which is in violation of the procedure prescribed by law. On the aforesaid grounds, the counsel for the petitioner has prayed for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner on the ground that 739 grams of heroin was seized in this case, which is a commercial quantity of contraband, and therefore the embargo of section 37 of the NDPS Act comes into play. It is also submitted by learned counsel for the petition, learned additional public prosecutor, that the court could not proceed with the trial as there are 4 accused persons and one of the accused person is yet to appear before the trial court. Stop. I have considered the submissions made by learned counsel for the parties as well as perused the materials available on record. It appears that total what was the total weight?
739 gram rupee.
It appears that total 739 grams of heroin was seized in this case from the possession of the accused persons including the present petitioner, and hence apparently the embargo of section 39 is applicable in this case. Stop. Regarding submissions made by learned counsel for the petitioner that the provision of section 52A was not complied with in this case as the sampling was not done in presence of the magistrate. However, on perusal of order dated 20/12/2022, it appears that the sampling was done in fact in presence of the magistrate, and from each of the 11 boxes 3 grams of suspected heroin was extracted as representative samples and was mixed homogeneously and thereafter marked, and the total weight of the sample was 11 grams. In each of the 3 samples, that is total 33 grams of samples. Therefore, the submission of learned counsel that 52A was not complied with cannot be appreciated at this stage. As regards submission made by learned counsel that there was delay in sending the samples to the FS forensic laboratory, the said plea can only be taken and considered during the course of the trial. Regarding the plea taken by the petitioner as regards the plea taken by the petitioner, learned counsel for the petitioner regarding the ground of prolonged incarceration, it appears that in all the 3 cases cited by, it appears that though prolonged incarceration is a valid ground for considering the prayer for bail, even in a case where commercial quantity of contraband is involved. However, before invoking the said provision, the court has to come to the conclusion that the incarceration is long enough so as to give the benefit of bail to the present to a petitioner. However, the cases cited by the learned counsel for the petitioner, in all the 3 cases cited by learned counsel for the petitioner, the petitioners of those cases were incarcerated for much longer period than the present petitioner in this case. In Nitish Adhikari's case, Supra, the petitioner was detained behind the bars for 1 year, 7 months. In Sariful Islam's case, within bracket Supra, the petitioner was in custody for over 1 year, 6 months. And in the case of Rabi Prakash, the petitioner was in custody for much longer period. However, in the instant case, the petitioner has only completed 471 days. That is about 1 year, 3 months only. Therefore, this court is of considered opinion that presently the incarceration of the present petitioner in this case is not long enough so as to override the embargo of section 37 of the NDPS Act. Therefore, however, considering the fact that even after 471 days of detention, the charges are yet to be framed, the trial court is hereby directed to look into the options of splitting up the case of the petitioner and the accused persons who are appearing before the court from that of the accused person who is yet to be apprehended, and proceed with the trial as expeditiously as possible. Stop. For above mentioned reasons, the prayer for bail of the present petitioner is rejected at this stage.
All right. Lordship, in this case, 2 years, 5 months, 11 days. And charge is yet to be framed, Lordship.
What was the seizure?
Lordship, seizure 413 kgs of cannabis, Lordship.
What was the date of the arrest?
Lordship, date of arrest 24/10/2021.
Two years,
5 months, 11 days.
What is the stage of trial?
Lordship, on 8/1/2024, that was fixed for evidence, Lordship. 2 of the witnesses has already been examined out of 7 witnesses. And 2 of the independent witnesses has been examined, and they have implicated, Lordship. Independent witnesses. And the person is in conscious position, Lordship. 413 kg ganja, Lordship.
Out of 7 witnesses, 2 have been examined.
Lordship.
What is your submission?
Lordship,
Same submission.
only 2, Lordship, and he is in custody for more than 2.5 years, Lordship. He may be released, Lordship, with any condition, Lordship. He will appear, Lordship.
When the charges were framed?
Charges.
5/7/2022, Lordship.
Yes.
It may be 3 also, but Lordship, 8/1/2024 was last date, but it is not up to date, Lordship. It may be.
Charge frame lordship 5/7/2022.
Depth one.
For prolonged more than after framing of charge, lordship only 2 witness examined. That part may be considered. It will take
What?
another 3-4 years, lordship.
No, how much time it will take, we are not concerned.
Lordship.
We are concerned how much time you are already behind the bars.
Lordship.
That is your ground.
Lordship.
Because
It is lordship.
7 witnesses are there.
Lordship.
7 witnesses can be examined in a single day.
That is.
There are other cases also.
So my lord, this already which I have cited, lordship relied, this case will cover
Which
lordship, my
cases?
case.
Which cases?
Nitish Adhikari, lordship and Shariful Islam, both the case cover lordship, 1 year 6 months, 1 year 7 months. So it is 2 years 5 months.
But Nitish Adhikari and Shariful Islam has not explained in detail the ground. Ravi Prakash has given the grounds. This has to be allowed. But you.
But my lord, the 2 witnesses are already implicated, lordship.
Okay,
Independent witnesses are there, lord.
I'm allowing the petition. But I'll write the order in the chamber.
My objection may be recorded. lord.
Obliged.
Chamber. This was item number?
16.
I'm taking 2 minutes break. It is on you.
Bashab Bey.
Mr.
Bashab Bey. Lordship, I am not in this case. I was asked by my senior to seek an adjournment for the day.
Okay. No, we are not adjourning, we are passing orders. Heard Mr. So-and-so appearing for the petitioner. Also heard Miss
M. Deka.
M. Deka, learned counsel for the NCB, who submits that the NCB has filed a written objection against the prayer for bail. However, same is not placed on record. The registry to place the written objection filed by the NCB on record and thereafter list this case on after Bihu.
Lordship, any date before Bihu to the court is convenient.
Now, this is NDPS case.
Yes, Lordship.
What is the offense? Under section commercial quantity
Yes, Lordship.
after
This
Bihu.
is Lordship, yes, Lordship, this is a recent case of complaint filed on 19/12/2023. Next date is 3/4/2024 for charges, framing of charges.
After Bihu. 26/4.
Obliged, Lordship.
It is the lordship, but 439 application. And I'll just briefly state the facts alleged in the FIR manual. But in this case, there was an information regarding presence of narcotic drugs, and accordingly, a surprise NACA was laid. And when my lord NACA was laid, during NACA checking, my lord, 2 persons were apprehended, namely Azimuddin and Amar Bahadur Chetri. And on their they confessed that, my lord, they have hide some narcotic drugs at the forest pala. Accordingly, police discovered that narcotics drugs, whether it's the cough syrup, bottle of some cough syrup. And now, my lord, I'll take your lordship to page 17, my lord, where my allegation, my lord, is
Page 17.
17, my lord. It's third paragraph, my lord, the lordship has got it.
What is this 17?
Yes, it is the FIR page, my lord, FIR conclusion.
FIR,
Yes.
okay.
During spot interrogation, the accused persons, namely Azimuddin, such and such, and Shri Amar Bahadur Chetri of village Rangamati Bazarichora could not give satisfactory answer regarding the said recovered narcotic drugs. They stated that Sandeep Datta is the owner of the recovered cough syrup. Accordingly, the same was seized in presence of the witness as mentioned above. As basis of their statement, one other person, namely Mongol Pal, son of such and such, PS Katlichora district, Hailakandi, also apprehended. So its present petitioner before the lordship is the Mongol Pal, my lord. And based on their confessional statement, my lord, he was arrested from his house, apprehended from his house, my lord. And
What was the accusation against you?
nothing, my lord. That much, my lord. The information was given.
When were you arrested?
Along with them, my lord, 5/11/2022, annexer 3 is the forwarding, my lord, page 27.
Yes.
Yes. So, my lord, take a lordship to now page 19, my lord. That is a Caesar part. May I read, my lord?
Yes.
Yes. I, Shri Jyoti Prasad Nagra PS, do hereby seize the below noted descriptive articles item from the possession of Muhammad Azimuddin, son and such and such, and Shri Amar Bahadur Chetri, Bazarichora district, Karimganj, in presence of below noted witness in connection with the above references. So, lordship will find in the Caesar list also my name is not there, my lord. The goods, the narcotic substance were seized from two persons, Azimuddin and Amar Bahadur Chetri. And when my lord forwarding, although I was forwarded along with them, but the IO specifically made page 29, my lord, the forwarding report. Requirement of police remand. During forwarding, my lord, they required, lordship has got it 29.
Yes.
Yes. Requirement of police remand, the accused person Azimuddin may kindly be allowed 5 days. During local inquiry, it is learned that accused Azimuddin is involved in the illegal business of cough syrup since long, and it is first he caught. So kindly remand Azimuddin for a period of 5 days for thorough interrogation and to trace out his company. And so, my lord, in the forwarding also, though I was forwarded, but no police remand has been sought. Thereafter, my charge sheet was laid, and now I'm facing trial. And in this case, my lord, one PW, not one, my lord. Although we have annexed one deposition of PW1, but subsequently 2, 3, and 4 witnesses were examined, my lord. I have the original copy certified by the bench assistant, my
No,
lord.
in charge sheet, what was the allegation against?
Allegation, my lord, is the same. I'll take your lordship to the charge sheet, my lord. Addition, must not be. There are so many original. Page 46, madam. Facts disclosed during investigation. This is the part of charge sheet, madam.
Yes. Yes.
May I read, my lord?
Relevant portion.
Relevant portion, yes. That is the second paragraph, my lord. After examining all facts and circumstances, a prima facie case under section 22C 2529 NDPS Act 1995 has been fully made out against arrested FIR named Azimuddin 1, Amar Bahadur Chetri 2, and Madan Pal 3.
Now, what was the allegation in the first paragraph against Madan Pal?
Yes, ma'am. During investigation of the case, PO was visited, recorded statement of complaining witness and accused person under section 161 CRPC. PO was drawn with the proper index, arrested the apprehended accused person Azimuddin, Amar Bahadur Chetri, and Madan Pal, and forwarded the arrested accused person to the honorable court and brought arrested accused person Nazimuddin for 5 days police remand. The seized exhibits along with seizure list by MR number were produced before judicial magistrate for scene, drawing a representative sample and seized suspected narcotic drugs codeine phosphate sent Kahilipara criminal and thereafter Lordship, several attempts. These were the allegations, my lord. Now the relevant parties, several attempts have been made to arrest the absconding prime accused Sandeep Datta, but he has been found absconding and there is no immediate possibility to arrest. Thus, sufficient evidence have been found against the FIR named arrested accused person Azimuddin, Amar Bahadur Chetri, Madan Pal, Sandeep Datta, for committing offence under section 20B2C 2529 of NDPS Act. So, but there is no specific thing.
Now,
neither
what is your submission?
Marat, the law with regard to the statement of co-accused is settled by Tufan Singh, Marat.
Tufan Singh is there.
Tufan Singh, I have got the Palula with Marat, where Tufan Singh has been relied upon.
No, but you have not brought the
I'll hand up
the citation on which you are relying.
The Palula with is also there, Marat. Same facts where the based on confessional statement, Marat, he was granted bail. Paragraph 10, Malat, if I may read.
No other material except
Except the confessional statements, Malat. Paragraph 10.
Supreme Court.
It has been held in clear terms in Tufan Singh versus State of Tamil Nadu, 2021 4 SCC 1 that a confessional statement recorded under section 67 of the NDPS Act will remain inadmissible in the trial of an offence under the NDPS Act.
What material is there? Again,
I wanted to a little bit background, Lordship. These two persons, Azim and Amar Bahadur, they were caught holes, Lordship, and they lead to the discovery of this drugs, Lordship, in jungle, Lordship, in a covert position. Azim and Amar Bahadur,
Amar, okay.
Chetri, Lordship. They took that place, and after the recovery of that 500 bottles of this codeine, Lordship, they went to this place, this auto, one Bajaj auto was there, Lordship. They took this investigating officer to that place, and the auto was of Sandeep Datta, Lordship. They were also present, and this was Madan. And this present petitioner, he was unloading and loading at the present site, Lordship. And when police came to that place,
no,
Lordship.
Police has not seen, police has been.
It is there, Lordship. I have flagged, Lordship. The circumstances as there, unloading.
Where?
In the CD, Lordship. In the CD, it is there.
Somebody has seen unloading.
Yes, Lordship. And in this PW4 is also there, Lordship. In the PW4 statement is also there, Lordship.
Lordship, I have the
This have to be taken together, Lordship. PW4 deposition, and I have flagged unloading, unloaded. And during that time, 20 bags.
What PW4 has stated?
In the last few lines, Lordship. 1, 2, 3, 4, 5, 6. PW4, Lordship.
No, what is this flag?
There is unloading. He is S29 is there, Lordship. So he is unloaded this cough syrup. He another Lordship transport one vehicle.
Who has said that he has unloaded?
Lordship, it is a note.
From where he came to know? I came to know that.
He was in present there, Lordship. He has stated the note in the note that with another vehicle, Lordship, these bags were bottles were taken, and he had not fully unloaded, Lordship. During the process,
No, just a minute.
police came, Lordship.
No, this loading, unloading, this has been stated by the accused. Prime accused have during interrogation mentioned that it was loaded and unloaded.
But I think I don't know.
Mark it. Underline it.
Lordship.
IO note is on the basis of some evidence which he has collected during investigation.
Lordship.
That in last paragraph, that note is on the basis of information which IO got to know during interrogation of Azim.
Lordship.
Azim said. Now his submission is that Azim's statement is not admissible against the co-accused as per Tufan.
But this is circumstances, Lordship. These circumstances that unloaded is there because both all the persons are in the same place, Lordship. Police, IO, this Azim, and this Lordship, Abdul. I think Abdul, Lordship. Shetri. All these persons are the same place, Lordship. It is not stated. It is, Lordship, because all these persons are, they led to the discovery, Lordship.
No, madam.
All these persons took these persons, Lordship. This Amar and Shetri and this police. Firstly, they took to the jungle, recovered this bags, Lordship. 500.
What I have understood, two accused persons, namely Azim and Amar,
Lordship,
were arrested.
Lordship.
During interrogation,
Lordship,
they took police to jungle,
Lordship,
from where the contraband was recovered.
Lordship,
and
500 bottles, Lordship.
Seized.
Lordship.
And thereafter further interrogation, they named.
Not Lordship. Then after further interrogation, they again took them to this auto, Lordship. And all of these persons are there. And then these persons, Madan, this person is also there. He absconded, Lordship. Sanjeev.
No, facts are not clear.
Yes,
First, they were that Omar Bahadur Chhetri and Azimuddin were stopped at the Naka checking, my lord. They led these police officials to the jungle where 252 bottles and 248 bottles of cough syrups were recovered. While they were coming back to the police stations, my lord, the police found an abandoned auto rickshaw, which according to them belonged to one Sadip Datto, and from the driving seat, they found another 20 numbers of bottles. So that is the allegations in the FIR. And thereafter, during interrogation of spot interrogation of Azimuddin and Amar Bahadur Chhetri, they revealed that Madan Pal is also there.
So against Madan, the only material is the statement of Azim and Amar. My query is, apart from Amar and Azim's statement, is there anything else to
In
show?
his possession, Lordship, these things has been recovered.
No.
Madan, Lordship.
Show me.
Lordship. Lordship in PW4.
What PW4 has?
Deposition, Lordship.
He is a member of the party, my lord.
Read PW4's deposition.
In last few lines, Lordship, on search,
Yes,
on search, Lordship got it.
PW4.
Lordship.
Just a minute. Yes,
On search, Lordship get it.
which page?
It is not page number. PW4.
Giving you Lordship separate copies.
Separate copies, Lordship.
Yes, PW4.
Lordship, on
On
last
search.
4 lines, Lordship.
Yes.
More Draksha.
Read it.
I will read from the beginning, Lordship.
Okay.
Incident took place on 5/11/2022. At that time, I was posted at Rangamati AD camp. On that day, at around 12 midnight, IC of Nagra PP received information that drugs were being transported. Thereafter, I, along with IC Nagra PP, Swapan Chaudhary proceeded to Rangamati Bridge. After searching the bridge, we saw two persons coming by bike. They were signaled to stop, but they did not comply and escape. Then they were apprehended by Das sir. They were interrogated and they told that drugs were concealed in the forest. They were taken to the forest and on being shown by them, cough syrup bottles were recovered in 2 gunny bags. They further stated that more drugs were kept in auto parked. They said, Lordship, by the side of the bridge on search. That means all these persons went to that place.
No,
On
that
search-
does not mean that. On
Okay, Lordship. Then on search, 1 carton was recovered from the auto.
Yes.
It belonged to one Sandeep Datta,
Yes.
which contained cough syrup bottles. Total 20 bottles from the carton in the auto and 248 plus 253 cough syrup bottles were recovered from the 2 gunny bags. The above cough syrup bottles were recovered from all the persons' names are there. Recovered is also what is there, Lordship, from Azimuddin, Amrit Bahadur Satri, alias Madan and Mangal, Lordship. Mangal is the present petitioner, Lordship. Recovered from his position, Lordship. And there are 2 independent witnesses present during the process, Lordship. So from this position also, Lordship.
Now, what is your submission regarding this?
My lord, the FIR is very specific, my lord, that during spot interrogation, his name was revealed, my lord. That thing has already been, I have shown, my lord, in the forwarding also, in the seizure list also, my lord. They were very specific that these articles were seized from the possession of Amar Bahadur Chetri and Azimuddin, my lord. And my name was not even there. And apart from that, my lord, this is, my lord, deposition by a member of the police party, my lord. And if your lordship revises the PW1 and PW2, we are Caesar witness, my lord, they have completely negated the presence. In fact, the prosecution case also, my lord. But I'm not, my lord, on that at this stage, my lord. My limited prayer is that apart from this statement of which is very apparent on the record, my lord, whether his further custodial detention is necessary, my lord.
Lordship, may I, Lordship? If I took that PW4 statement, Lordship, deposition, and if I take this note, Lordship, if I take this
What
note,
that note says?
Lordship, it is to be noted that during interrogation of the arrested accused person, it has been established that prima facie Sri Sandeep Datta has brought the seized cough syrup to Rangabati by an unknown vehicle, Lordship, and tried to load the bags of suspected codeine, phosphate syrup, cough syrup to his vehicle, Bajaj Auto, Lordship. This is going on, Lordship, to transport to Hamsera, Tripura, along with his Lordship, arrested accused worker Madan Paul, the present petitioner, Lordship, but could not load the 2 bags of suspected codeine cough syrup and loaded only 1, Lordship, small carton of containing 20 bottles of 100 ml each to his vehicle, Lordship. And other 2 arrested accused person concealed 2 bags of suspected codeine phosphate cough syrup in the nearby jungle at Rangamati due to fear of police and seen by local people. The prime accused, Sandeep Datta, is absconding, Lordship. And it reveals that he had been running illegal business, that is on, Lordship.
Forwarding says.
In the light of this statement, Lordship.
Azimuddin is
Deposition, Lordship.
Lordship, kindly peruse page 51, that is the deposition of PW1, my lord, which is a Caesar witness. PW2 also I have an my lord. Just read 1 paragraph, my lord. Page 51, my lord. That is the deposition of PW1. He is a Caesar witness, my lord. Independent witness relied by the prosecution. May I read, my lord?
Yes.
Married, ma'am. Incident took place more than 1 year at around 3 a.m. I was called by police from my home. I came to the main road, which is adjacent to my house, and saw two gunny bags being brought down from a Bolero. That Bolero probably they were driving, my lord. But brought down from a Bolero, and from one gunny bag, 248 cough syrup bottles were recovered, and from another gunny bag, 252 cough syrup bottles were recovered. There was an auto also, from which 20 number of cough syrup bottles were recovered. The above cough syrup Mangalpal, Majimpal, one auto, police, one auto, one bike, and recovered cough syrup, and my signature was taken in the seizure list. So they brought this, my lord, and he was called upon to sign the witnesses. They brought this things in a Bolero manner.
But your name is also there.
Lordship, Lordship. name is
They are
there.
also, my lord, on the prayer of the page 52 also, Lordship.
No, but your case was, there is no material.
Lordship, that is what I want to.
The
My lord, that part I have, my lord, made my categorical statement, my lord, how I have been taken into custody, my lord, by the prosecution, my lord.
No. That initial you have not raised this plea when there was only material was the co-accused statement. Now, as on today, apart from statement of co-accused, the statement of PW1 and PW4 are also there against you. Whether that is, they have stated true or false, that will be decided only in trial, but materials are there. PW1 has also named you. PW4 has also named you. Now, whether they are reliable or not, in the bail application, we cannot decide that. Had these two witnesses were not there, then you had a case.
My lord, these two prosecution witnesses were declared hostile, and paragraph 11 of his cross-examination by the defense, my lord. Paragraph 11, my lord. Madan was guarding the fishery, my lord.
And 4, no, this, I don't think. And PW4?
PW4, my lord.
PW4 has named you. During,
Official witnesses, he has named.
during cross, you have not demolished that portion.
Along with that, it is also a fact that during spot interrogation, Madan Pal was arrested, my lord. That thing also PW1 stated, my lord, in paragraph 11. And
No, but now this is not a case where the only material is co-accused statement. There is something else. Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mongol Pal alias Madan Pal, who is detained behind the bars since 5/11/2022. In connection with special NDPS case number 158/2022, corresponding to Bajari Chera PS case number 194/2022, pending in the Court of Learned Special Judge Karimganj under section 22C/25/29 of the NDPS Act, 1985. This case was initiated on the basis of an FIR which was lodged on 5/11/2022 by one Shri Jyoti Prasad Das, comma, in charge of Nagra PP Police Post before the officer in charge of Bajarichera Police Station. Comma, inter alia, comma, alleging that inter alia mentioning that on the basis of specific information received, a Naka checking was conducted near Rangamati Bridge. And during the Naka checking, one motorcycle bearing registration number RGN, bearing registration number AS 11D 2500 was found coming towards the Naka checking point. And when it was signaled to stop, to be stopped, they tried to escape from that place. However, police personnel present there were able to apprehend both the motorcycle rider, and they were found to be one Azim Uddin and one Amar Bahadur Chetri, who during interrogation led the police team to a jungle from where $252 numbers of bottles of cough syrup were recovered, and also two separate recovery of 248 number of cough syrup bottle was made. It was also alleged in the FIR that separate recovery of 20 numbers of cough syrup bottles were also made from the vehicle bearing registration number AS 10AC 6413. Stop. Learned counsel for the petitioner has submitted that no recovery was made from the present petitioner, and the present petitioner, namely Mangal Paul, was apprehended only on the basis of the statement made by the co-accused. Stop.
My lord, PW 4, 25 and 26, Lordship, kindly have a look for a moment, my lord. PW 4, my lord, cross-examination part clause 25 and 26, where he has stated, my lord, that he was apprehended after 25 and 26, my lord, and recoveries were made from Amrit Chetri and Azimuddin. That query, Lordship, put to me that you have not.
No, but that is at this stage is only a suggestion.
That's very specific, my lord, that no recovery was made.
He has denied that.
26, my lord. It is not a fact that no cough syrup was recovered from Amrit Chetri and Azimuddin from the forest or from the auto.
He has denied that.
Yes, denied. This is not a fact that. So Amrit Bahadur Chetri and Azimuddin were the person from whom, on being led by them, cough syrups were recovered. That is the admitted position, man. Nothing has been recovered from this petitioner.
No, this suggestion says that no recovery was made from Amrit Chetri and Azimuddin. That he has denied.
Yeah.
So the net result is that your suggestion was not accepted. So at this stage, this has no value. What was the last name? So it is pertinent to mention herein that after completion of the investigation, charge sheet was laid against 4 accused persons, including the present petitioner. The main ground for seeking bail by the present petitioner, which has been pressed by learned counsel for the petitioner, is that the petitioner was implicated in this case only on the basis of the statement of two co-accused, namely Azimuddin and Amar Chetri, and no other material is there on record against the present petitioner. Learned counsel for the petitioner has also pointed towards the charge sheet, which copy of which is available in the case record, and has submitted that even in the charge sheet, no accusation has been made against the present petitioner, except the fact that he was apprehended on the basis of statement made by the co-accused. Learned counsel for the petitioner has cited a ruling of Apex Court of India in the case of Tufan Singh versus State of Tamil Nadu, reported in Manu/SC/0797/2020. No, reported in 2021 4 SCC 1, Manutu Katili, 4 SCC 1, wherein the Apex Court has observed that the statement of a co-accused recorded under section 67 will not be admissible in trial against in an offense under section 1, in an offense under NDPS Act. Now, on the other hand, learned additional public prosecutor has submitted that in this case, the already how many witnesses?
4, madam.
4. Already 4 witnesses have been examined and the trial is progressing. It is also submitted that during trial, the PW1 and PW4 have categorically implicated the present petitioner as and has stated that the contraband was and has stated that the contraband was also recovered from the possession of the present petitioner. Though it is true that the statement of the co-accused cannot be a basis of proceeding in a trial under section NDPS Act, and though in the charge sheet the IO had not mentioned in detail the accusation against the present petitioner, however, at this stage of when the trial is proceeding and when 4 witnesses have been examined, and when 2 of the said 4 witnesses, namely PW1 and PW4, have implicated the present petitioner, this case does not fall within the category where the accusation is only on the basis of the statement of co-accused. Therefore, this case is not covered under the case of Tufan Singh versus State of Tamil Nadu. As there are other materials also on record incriminating the present petitioner. As the quantity of contraband is, in this case, is of commercial quantity. Hence, the embargo of section 37 is applicable in this case, and which the petitioner is unable to overcome. Hence, the prayer for bail. For the reasons stated herein before, the prayer for bail of the present petitioner is thereby rejected.
Only, I want to only clarify that in the scan copy lordship in record, only PW one statement is there.
PW4 is also produced.
Yes.
No,
I have
for-
produced, the copies were provided
Lordship.
me by the.
We are relying.
Lordship.
It has gone against you.
Yes, no, Madam, sir.
Lordship.
What is true is true, Madam.
Lordship.
But can I have that copies again, Madam?
You return back the copy.
Keep your plan.
Which one?
Lordship, this matter may be fixed on tomorrow, along with other NCB
Tomorrow
matters.
with the other NCB matters.
Tomorrow will be NCB day. On request of learned counsel for both the side parties, let this matter be listed on 4th of April 2024.
Lordship, this matter may be fixed tomorrow, fixed on tomorrow, Lordship. We have received case diary, but my senior is on legs in another court. And my senior will not be able to come on second half, Lordship.
Okay, instead of tomorrow, my lord, there is a
Lordship,
Monday, my lord.
Monday, because Lordship, we have to return case diary to CSO, Lordship.
My lord, after.
But tomorrow we are having.
Perhaps it is third or fourth occasion.
It is commercial quantity.
My lord. My lord, let it be Monday, my lord.
Monday,
Okay, Lordship.
on request of learned counsel for both the sides, let this matter be listed on 8th of April 2024.
Acha, Lordship, similar prayer.
Same order, Monday.
Not Monday, tomorrow.
Tomorrow. Okay, tomorrow,
Acha,
same order.
Intermediate quantity, today is 50 days in custody. And
When were you arrested?
13th of February,
13 to,
13 to.
how many days?
As on today, 50 days,
50.
my lord.
Pending for FSR, lordship. Otherwise, mother cease from his position.
Otherwise, progress of investigation.
Okay, only mother, it is pending for FSR, lordship. Otherwise, mother sufficiently progress.
Okay, heard Mr.
M.A. Islam.
M.A. Islam, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Muhammad Minaz Uddin, alias Muhammad Minhaz Uddin, who has been detained behind the bars since 12/2/2024 within bracket for last 50 days in connection with Dispur PS case number 120/2024 under section 21B of the NDPS Act, 1985. The gist of accusation in this case is that on 12/2/2024, one Parismita Mudoi, SI of police, had lodged an FIR before the officer in charge of Dispur police station, inter alia, alleging that what was the recovery?
heroin, my lord.
How much?
184.
184 gram. my lord.
184 grams of heroin was recovered from the bumper of the vehicle bearing registration number MN01AK5059. Who are you? You are the driver
And the driver, my
or owner?
lord. No, driver. And owner, my lord, he was actually the owner of the goods, my lord. He was sitting in the car, but on seeing the police, my lord, he fled from the car.
The present petitioner is the driver of the said vehicle. Stop. Learned counsel for the petitioner has submitted that the seized contraband which was recovered in this case does not belong to the present petitioner, and the owner of the said contraband, who was also traveling in the said vehicle, fled away from that place when the search and seizure was made. Learned counsel for the petitioner has also submitted that, considering the period of detention, the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that the investigation has fairly progressed and it is pending only
To collect FSL report also.
for
And I have,
collection,
my lord, collected sufficient materials against him.
only for the collection of the forensic laboratory report. It is also submitted by learned counsel for the petitioner that, and learned additional public prosecutor, that the investigating officer has collected sufficient incriminating material against the present petitioner. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of dispute PS case number 120/2024. Though there are incriminating materials against the present petitioner, however, considering the fact that the contraband seized in this case is of intermediate quantity and the maximum period for which the petitioner can be detained during investigation under section 167 of the CRPC is only 60 days, whereas he has already completed 50 days behind the bar. Stop. Considering the period of detention already undergone by the petitioner, as well as considering the progress made in the investigation, further custodial detention of the present petitioner does not appear to be necessary for completion of the investigation of dispute PS case number 120/2024. Stop. In view of above, the above named petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Kamrup Metro, with following conditions. Condition number 1 and 2. With this observation, the bail application is hereby disposed of.
Highly obliged.
Item 23.
May I plead, Lordship? 439 application, Lordship. Allegation under section 379/401. I was arrested on 9/2/24 and behind the bar for 53 days as on today, Your Lordship.
9/2/24.
53 days behind the bar. 53 days. 60 days mandatory, both the sections illustrated.
My lord, they are veteran, my lord, bike and car lifter, lordship. And from their possession, my lord, one stolen scooty has been recovered. And lordship, some equipment, lordship, which are usually used to break the lock of the, my lord, steering vehicle, my lord. These items, my lord, few equipments are also recovered from their possession, my lord.
As per the FIR, Your Lordship, no offenses has been committed. On road, when we are coming from our work, we are arrested, Your Lordship. And some, we are
What was the
daily
allegation?
laborers.
What was the allegation?
That Your Lordship, may I read the vernacular is in page number 17, FIR, Lordship.
Yes. Yes.
উপরোক্ত প্রসঙ্গ থানার ভাৰপ্ৰাপ্ত বিষয়া মহোদয় মোৰ বিনীত ব্যৱস্থা লোৱাৰ বাবে নিৰ্দেশ দিয়াত মই সংগী ষ্টাফ সত্ৰ থানা এলেকাৰ নট বোমা তালাচী অভিযান এখন নম্বৰবিহীন স্কুটি প্ৰায় 2:30 মান বজাত দুজন লোকক আটক কৰিবলৈ সক্ষম হওঁ স্কুটিখন ভালদৰে নিৰীক্ষণ কৰাত তলাটো ভঙা দেখা পাওঁ আটক কৰা লোকজনৰ পৰা কিছুমান চুৰি কাৰ্য ব্যৱহাৰ কৰা সংযম পাওঁ স্কুটিখনৰ বিষয়ে সোধাত তেওঁলোকে 4 দিন মান আগৰ গড়চুক এলেকাৰ পৰা চুৰি কৰি আনা বুলি স্বীকাৰ কৰে লগতে আজি তেওঁলোকৰ উক্ত এলেকাত গাড়ী চুৰ কৰাৰ বাবে অহা বুলি ব্যক্ত কৰে there is no incident taken place.
No, but you admitted that it was stolen.
This is the FIR given by the IO, Your Lordship, the police officer. Here, even the time mentioned, Your Lordship, 2:30, Your Lordship. According to that type copy of the FIR, what they says, Your Lordship, kindly please page number 14, Your Lordship. Page number 14, the front line, Your Lordship. Date and time of the arrest, Your Lordship, 9/2/24. It is 12:45 hours, Your Lordship. It is during the day, 9/2/24 during day 12 o'clock. It is.
No,
that is-
okay.
Yeah.
They have been for last 53 days.
Yes, Madam. That is true, Madam, but only.
But
thing is
whether
that-
IO could find out whose scooty is this?
No, that is under investigation, also. That is under investigation, and
No.
they have also, Madam, stated that it is stolen one. Madam, only question is that after releasing on bail, they will again start this profession.
They are small.
So they are veteran.
Young boy behind the bar for 53 days.
Mr.
55 days also, my calculation.
Oh.
50?
55 days. One.
Heard Mr.
R. Chetri.
R. Chetri, learned counsel for the petitioner. Also heard Mr. R. J. Borwal, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Binaram Basumatari, who has been detained behind the bars since 9/2/2024, within bracket for last 55 days, in connection with Bashishta PS case number 82/2024 under section 379/401 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 9/2/2024, one Osman Ghani of Bashishta Police Station lodged an FIR before the officer in charge of Bashishta Police Station, inter alia, alleging that one scooty without number plate was recovered from the possession of the present petitioner and one Mridul Boro. And during interrogation, they have admitted that they have stolen the said scooty from Gorsuk area. In the said scooty, the lock of the said scooty was found to be broken, and some other instruments which are used in stealing which may be used in theft were found stopped. Learned counsel for the petitioner has submitted that no one has lodged the FIR. No owner of the scooty has lodged the FIR against the present petitioner. It is also submitted that the petitioner has been detained behind the bar since last 55 days, and considering the period of detention already undergone, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Basishta PS case number 82 and 82/2024 and has opposed the grant of bail to the present petitioner on the ground that the petitioner and the co-accused are veteran vehicle lifters, and the owner of the seized scooty is yet to be found.
And my lord, several incriminating materials also, which was used in my lord, lifting the my lord current bike were recovered from their possession.
And several incriminating materials which are used in stealing the car and bike were found from the possession of the present petitioner. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the case diary of Basishta PS case number 82/24. Though there are incriminating materials against the present petitioners in the case diary, however, considering the period of detention already undergone within the 55 days by the accused, by the petitioner, his further detention may not be necessary for fair completion of the investigation of Basishta PS case number 82/2024. Hence, the above named petitioner is hereby directed to be released on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. With above observation, the bail application is hereby disposed.
Obliged.
Item number 41.
May I please, your lordship? The case for suspension of sentence, my lord. In this case, basically, the appeal is already been admitted, where his accused appellant been convicted for 7 years for the case of arson, my lord. He is the sole accused in this case, my lord. The whole case is based upon the one eyewitness, my lord. Only one eyewitness, PW2.
Okay.
Rest are just reported witnesses. The 5 witnesses been examined. PW2 is the only witness, my lord. Now, lordship, can you turn to my appeal memo, my lord? Please. I have annexed all the depositions of the witnesses, my lord. Lordship, can you turn to page 45, my lord?
Yes.
He is claimed to be the eyewitness in the whole occurrence, my lord. May I read, my lord?
Yes.
My father is a complainant in this case. I know the accused person present in the dock. His name is Abdul Kalam Majumdar, and the incident occurred about 2 years back on day of so-and-so. At the time of the incident, my father was sleeping in his house. I was also sleeping in my own house. He was also sleeping adjacent thereto. Suddenly, I heard a sound of my mother, "Bachao, bachao, save, save." Accordingly, I came out and saw 3-4 persons was running away. However, I could identify the present accused person, Abdul Kalam Majumdar. I made the attempt to rescue my father through the door, but the door did not open. I thought that the door was locked from inside. Thereafter, I cut down the bamboo fencing and rescued my father from the burning house. We tried to put off the fire but could not, as a result of which the household article of my father, including the documents, burnt ashes. I found that the door of the father was tied from the outside by Glamhajar's wife. The next, my father lost the Ezaha. During the investigation, police officer visited their place twice and seized the small tin box, 2 pieces of the half-burned wood, so and so, so and so, so and so. Next page, 47. Today, I have seen the seized articles such as the 2 small-sized tin boxes, 2 pieces of the half-burned wood. My father's Stretch's house was measuring so and so bamboo walls and the roof. Police also recorded my statement during the investigation. Now cross-part. We had 2 houses at the time of occurrence, one at the western side and another at the southern side. We are 4 brothers, all the other living western side. My father has 3 brothers. My uncle Azizuddin resides in the eastern side and the Hilaluddin resides in the western side. When I saw the accused person, he was running towards the western side. The court eastern side. The courtyard is situated towards the eastern side and then one connecting road towards the PW. I saw the accused person on the road by the face side. At the time of occurrence, there was electric connection in the other houses, but in the alleged houses, there is no connection. The other house is situated in a hillock. The village part started from the lower part of the hillock, which connects the PW road. This is not important, my lord. My lords. Next page 49. We had a cow shed in the eastern side of the state. In the next paragraph, my lord. It is not a fact that I did not state before the police that I heard the sound of my father Bachao Basao. Save accordingly, I came out and saw 3-4 persons were running away. However, I could identify the present accused person, Abdul Kalam Majumdar. Now, last paragraph also, my lord. It is not a fact that I did not see the accused person running away towards eastern side. I did not see the accused person setting fire in my father's house. Just the admission, my lord. He did not see the accused person in setting fire in my father's house. Admitted position, my lord. Only what he saw, my lord, that I was running 3-4 persons along with me, my lord. We are running towards the eastern side. That is his deposition. Only based on these deposition, my lord, I have been convicted, my lord. Now, lordship, kindly turn to IOS cross, my lord, page 63.
Yes.
Page 63, my lord, the contradiction, my lord. PW2, my lord, as your lordship got it, my lord.
Yes.
PW2, the Imdadul Rahman did not state before me specifically that I heard sound of my father, Bachao. Accordingly, I came out and saw 3-4 persons running away. However, I could identify the present accused person, Abdul Kalam Majumdar. So this contradiction has been proved, my lord. So that's the case, my lord. The whole case is based on my conviction. Lordship, kindly see the paragraph, page 25, my lord. Of the judgment, my lord, para 19.2, my lord. Page 25, my lord. The 19.2 starts from page 24. On meticulous scrutiny, on the 4th line I am reading, my lord. On meticulous scrutiny of the evidence so far produced before the prosecution, it reflects that there was no eyewitness who could see as to who had set fire in the house of the complainant. However, from the evidence of PW2, it is crystal clear that when he came out the hearing sounds of the father, he saw the accused person facing trial running away from the place of occurrence. The incident occurred during the midnight. Naturally, it could not be expected that somebody would sit somewhere to watch was coming to do something wrong in the complaint. It is a fact that PW2, the fact that the PW2 saw the accused person immediately thereafter the house started burning since has remained unrebutted is thereof proof that it is none but the accused person who set fire in the house of the company. That is absolutely perverse, my lord. And Lordship has seen that the contradiction already been proved. His statement for the first time in the court that has been proved through the IO. Whereas
Since when you are in jail?
I'm last 7 months in the jail, madam. 28/8/2023, madam. Only evidence is that, madam.
Defense side, Lordship, did not deny the burning of the house, Lordship, although they have said that Lordship cow shed, Lordship, is a cow shed, Lordship. The prosecution witness number 2, Lordship, could identify the accused person, Lordship, who is running away, Lordship, after burning, Lordship. Though he was not eyewitness, Lordship. At the in the time of 1 AM or Lordship, it is Lordship, necessarily Lordship, nobody is waiting there, Lordship, to see the persons who is coming and burning the house, Lordship. After shouting, Lordship, he came out from his house and found that, Lordship, the 3 or 4 accused persons went out, Lordship, and running away from the place of occurrence, Lordship. So, Lordship, he could identify, Lordship. He categorically state that, and his evidence also not rebutted, Lordship, remain unrebutted, Lordship. And DW 3 and 4 also, Lordship, came out from their house, Lordship, after hearing the sound, Lordship, and shouting, Lordship, and found that, Lordship, the victim is, Lordship, fainted condition, in a fainted condition, Lordship.
Mr. A. M. Bora. And I, anything?
Here, language has already stated
We
that
are,
the PW.
we are considering the I only.
Yes, sir. Yes, Lordship. This is the statement of the PW2, who stated that when the house was burning, he came out and he saw 4 persons, and out of 4 persons, the accused he was able to recognize. Now, Lordship, from the other part also, other PWs are also there. It is clear that there is a personal enmity between the accused petitioner.
But only PW2.
PW2 is only the person, and he stated that he saw they ran out. Now, Lordship, the thing is that the distance from the house of the PW2 to the victim and to the accused convict is about 1.5 kilometers. And about night, at about 1 AM, for what reason the persons were available there and they ran out from there. So that is also Lordship, we have to consider in this regard.
Okay, heard, Mr.
He is not a neighbor.
A. M. Bora, learned senior counsel for the petitioner, assisted by Mr. V. H. Chaudhary, learned counsel for the applicant. Also heard Mr. K. Bosher, learned additional public prosecutor, as well as Mr. V. U. Laskar, appearing for the informant. This interlocutory application has been registered on filing of an application under section 389 of the Code of Criminal Procedure 1973 by the applicant, namely, who is the applicant?
Abdul Kalam Majumdar.
Applicant, namely Abdul Kalam Mandal.
Abdul Kalam.
Who has praying for suspension of sentence imposed on the present applicant by the judgment dated 28/8/2023 passed by learned additional session judge Hailakandi in sessions case number 94/2022 whereby the present applicant was convicted under section 436 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 10,000 only, and in default of payment of fine, to undergo further imprisonment for 3 months. The said judgment, the aforesaid judgment has been impugned by the applicant by filing a connected criminal appeal, which is registered as criminal appeal number 346/2023. Learned senior counsel for the applicant has submitted that by the impugned judgment, the trial court has convicted the present applicant under section 436 of the Indian Penal Code for burning the house of whom?
Informant.
House of the informant. And the trial court reached the said conclusion, burning the house of the informant. It is also submitted by learned counsel for the applicant that though the prosecution side had examined 5 prosecution witnesses, the trial court mainly relied on the testimony of PW2 for convicting the present applicant under section 436 of the Indian Penal Code. It is also submitted by learned counsel for the applicant that the PW2 has deposed during his cross-examination that he had not seen the present applicant setting the house of the informant on fire, and he had only seen the present applicant running where is PW2's deposition page?
Page 45. Towards eastern side.
Running towards eastern sides. He only saw 3 to 4 persons running away from the house of the applicant, and he could identify the present applicant amongst those 3 to 4 persons. However, learned senior counsel has also submitted that the said testimony of the applicant was contradicted by the by his earlier statement, as the investigating officer who had deposed as PW 5 has stated during his cross-examination that PW2 had not stated before him that he saw the 3 to 4 persons running away, and that he could identify the present applicant amongst the said 3 to 4 persons. Learned senior counsel for the petitioner applicant has also submitted that the trial court had erred in relying on the testimony of the PW2 in convicting the present applicant, in spite of the fact that his testimony was contradicted by his by the testimony of PW5, the investigating officer, learned counsel for the applicant has also submitted that the as the conviction has been based on the testimony of only PW2, which was also contradicted by his previous statement. There is every possibility of the applicant getting a verdict of acquittal in the connected criminal appeal. And as the sentence imposed on the present applicant is only for 7 years, he would be prejudiced if he is not allowed to go on bail during the pendency of the connected criminal appeal. On the other hand, learned additional public prosecutor and as well as learned counsel for the applicant, learned counsel for the informant have submitted that the trial court had rightly convicted the applicant under section 436 of the Indian Penal Code, as the PW2 has categorically mentioned the name of the present applicant, and as he has been identified by PW2, the trial court was not wrong in coming to the finding of guilt of the present applicant under section 436 of the Indian Penal Code. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. It appears that the trial court has mainly relied upon the testimony of PW2, who has stated that he had identified the present appellant while he was running away from the house of his father along with 2 to 3 other persons. However, it also appears that the said testimony was contradicted by the PW5, who is the investigating officer and who deposed that the PW2 had not stated so before the PW5 while during the investigation. Considering the fact that apparently there appears to be a contradiction in the testimony of the PW2, which he gave before the trial court, there seems to be a arguable case in favor of the present applicant in the connected appeal. And also considering the fact that as the applicant has been convicted, has been sentenced only for a short duration of, only for a duration of 7 years. And further considering the fact that the appeal connected criminal appeal being registered only in the year 2023, it is unlikelihood that same would be heard very soon. And therefore, unless the operation of the impugned judgment is suspended during the pendency of the connected criminal appeal, the applicant would suffer prejudice if ultimately he is found to be innocent and his appeal is ultimately allowed. Therefore, stop. For the reasons mentioned above, the operation of impugned judgment dated 24/8/2023 is hereby suspended during the pendency of the connected criminal appeal number 94/2022. And the petitioner and the applicant is allowed to go on bail of rupees 30,000 with one surety of like amount to the satisfaction of learned Sessions Judge Hailakandi, with following condition that he shall surrender before the Court of Learned Session Judge if ultimately the appeal is decided against him and he is directed to surrender, if he is directed to surrender before the Sessions Court. He shall not indulge in any offense for which, any offense similar to that for which he has been convicted in this case during the pendency of the connected criminal appeal. With above observation, the aforesaid interlocutory application is hereby disposed of. In main case, whether LCR has come.
Yeah, fixed for hearing, no, fixed for.
Paper book would not be required.
No.
Okay. In the main case, heard Mr. A.M. Bora, learned senior counsel, assisted by Mr. B.H. Chaudhary, learned counsel for the appellant. Also heard Mr. K. Bosho, learned additional public prosecutor, as well as Mr. P.U. Laskar, learned counsel for the informant. The trial court record has arrived. The case is ready for hearing. List this appeal for hearing in its usual course.
Published. Well, the date of judgment is 24/8/2023. And
And
the
sentencing is.
sentence is 28/8/23.
Okay, I'll make corrections.
Obliged.
Highly obliged.
Item 24.
My please, my lord, this is my lord, 439 bail application, my lord. He is in custody, my lord, since my lord, 2/12/2023, my lord, more than 4 months, my lord. And it's a suscited case, my lord, and his LCA has been received, my lord. That's
Victim?
all.
My lord, that is a service not completed. I have.
We have taken steps already.
You have taken steps by registered posts.
Registered as well as my lord,
No,
ordinary.
Mr. Sharma,
My lord.
you can take information through the jurisdictional OC, why the
Fine.
service has not been completed.
Yes.
When will you? Because notice has to be served.
My lord.
Lordship.
Notice on respondent number 2 has not yet been served, although you have taken steps. You have taken steps through registered posts.
Registered post as well as my lord, usual process. Both the ways, my lord.
Official answer is not taken.
Yes, that is also taken. 3 ways, my lord, I have taken, my lord, as per the order of this court, my lord.
So what is to be done?
And your
My lord,
lordship,
I will take instruction. My lord.
draw presumption that, my lord, since it is sent on 19 itself, my lord. So, my lord, they might have received, my lord.
Or you take fresh steps through jurisdictional police station.
Probably they have received, my lord.
Then you take information.
My lord.
Today, can you take?
No,
Yes, my
today not possible. My lord, I will have to
send further, if not, if you manage then.
Heard Mr. J.C. Bora.
Day after tomorrow, my.
Heard Mr. J.C. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Though the scanned copy of the record which was called for has arrived. However, from the office note dated 1/4/2024, it appears that the service report of the notice sent to the respondent number 2 has not yet arrived. Learned additional public prosecutor, Mr. B. Sharma,
My lord.
is requested to take information from the officer in charge of Mayang Police Station
My lord.
regarding service of notice on.
Hosai, my lord, Hosai. Informant is,
Oh, sorry.
page 2, my lord.
Of Hojai Police Station regarding service of notice on the respondent number 2 and inform this court on the next date, that is on 5th of.
My lord.
Can it be tomorrow, my lord, because he is already behind the bar for more than 4 months, my lord.
My lord, if not
In fact,
received, my
it's a
lord, then
case-
I will have to send.
In
my
fact,
again.
it's a
Then
case,
you take information by tomorrow. Because if he has not received, then again fresh.
My lord,
yes,
Yeah.
my lord, my lord.
tomorrow.
No, tomorrow, 4th of April.
I'm deeply obliged.
I am on behalf of Srinagar Extra Chaudhary Lordship. Today he is not present today.
My lord, here CD not received, my lord,
He
today.
was called for.
CD was called from, my lord.
Okay.
Service also, service company.
Heard Mr.
M. Hawk.
M. Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for another date for producing the case diary. It also appears that the service report of notice issued to the respondent number 2 through the officer in charge of jurisdictional police station has also not been received. Learned additional public prosecutor is requested to contact the officer in charge of jurisdictional police station and inform this court on the next date fixed regarding the service of notice on respondent.
My
number 2. Let this case be listed again on the notice.
My lord.
26.
4.
4.
I think item number 9.
Okay.
May I please, Your Lordship? This item would possibly, my lord, second application at page 44, my lord. We should possibly go to page 44, my lord. We have annexed that order, my lord.
No, earlier it was withdrawn.
Whether I do not know, my lord. We have the facts I have placed before your lordships.
Whether I can take it up.
I don't know, my lord. That is why I'm saying.
I cannot take it up.
Coordinate, possibly it would, I don't know, my
It will go to the.
lord. That this particular bench.
Yes. Registry, it appears that heard Mr. B. K. Mahajan, learned counsel for the petitioner, also heard Mr. K. Bashaw, learned counsel, learned additional public prosecutor. It appears that the earlier petition and earlier petition for anticipatory bail filed by the present applicant was dismissed on withdrawal by the coordinate bench of this court, within bracket Honorable Mrs. Justice Malashi Nandi, on 23/2/2024. Therefore, this matter has to be listed before appropriate bench, registry to do so.
Highly obliged.
Item 45 from supplementary list.
Forty-five, 46, 47.
Timing.
Lordship, 45,
Lordship, item number 45, 46, and 47. Look by Lada Deputy RJ Borua. Lordship, he is in on leaks in another court. Maybe up to time being Lordship.
No, let us first go. 45 is looked after by RJ.
45, 46, and 47. Three. Lordship.
Okay, let him come.
Yes.
We'll take it up.
Otherwise, I have concluded my part. Only he needs.
No,
to-
What was your
My condition was that section 29 is not there because personal quantity which is recovered, that will be taken into consideration, and delay ground. Now he needs to reply on that. Delay, he is 1 year.
You have to refresh it. Let him come.
Okay.
Item 48.
Wait, please, your lordship. This is a 439 bail application, lordship. In this case, this petitioner in jail.
48.
Oh, sorry. I'm for 48.
Lordship, pass over for time being. My senior is on late.
Item 40.
48.
Okay.
I'm here.
49.
48.
40.
But there is an application where the party petitioner is in jail custody
48.
since 1 year, 9 months. Now it's been since 1 year, 10 months we have been in custody. Charge was framed on 27/3/23. And I was arrested on 30/5/2022. On the basis of a statement given by co-accused. And that co-accused has been granted bail by the Honorable Supreme Court. The order I have annexed at page 53.
What was the ground?
The ground for long incarceration in the custody, if I were to take a lordship to page 53,
Yes. Yes.
My lord, may kindly come to, my lord, may kindly come to page 37. Page 37 will show the petitioner who has been enlarged on bail by the Supreme Court.
No, sound change.
Surnames are same.
Okay. Yes.
My lord, page 37, if your lordship sees, this is the 161 statement of the person who has been enlarged on bail by the Honorable Apex Court.
Page
37. He is the man who has sent the consignment.
Okay.
And the allegation is that I am
Charge
the
sheet was laid against 2 accused persons.
charge sheet was laid against more than 2 accused person, my lord. Three accused person.
This person, the petitioner, and one more.
Petitioner and 2 more,
Including,
is-
including Amal Das.
including Amal Das. The driver is on bail. Amal Das is on bail. And this is me, my lord.
Who are you?
I am, according to the allegation, I am the consignee. Consignor is on bail by Supreme Court Amal Das, and I am the consignee. Nothing has been recovered from me. Admittedly, I also run a pharmaceutical business. My trade license is also annexed along with this petition. Your lordship will find it at page number.
Your name is Sumit Das.
Sumit Dhar.
Sumit Dhar.
My trade license, your lordship will find at page 25.
Yes. Okay.
That's my case, my lord.
Now, on what grounds Supreme Court released the co-accused?
My lord, the Supreme Court released the case is number 1 on the length of detention, 1 year, 9 months, which your lordship will find at page 54, the second line. In fact, my case is better than this case at page number 54 because he had a record of previous conviction. As not conviction, there was an NDPS case against him, and there is a mention of that. But since in that case he was acquitted, therefore the court said 1 year, 9 months, and there are 20 witnesses to be examined. Page 54, the second line.
But Apex Court has not mentioned why it is granting bail.
My lord, it is mentioned the appellant is in custody for approximately 1 year and 9 months. Charge sheet was filed on 18/7/2022. It is also stated that additional charge sheet has to be filed, and there are 20 witnesses to be examined in the trial. In response to the submission of the learned counsel for the respondent appearing for the state, petitioner's counsel submitted that in the earlier case, because the submission was made that there is a case pending. In the earlier case, the petitioner has been acquitted that he is a trader dealing in medical products. Considering the facts on record, in our view, the case for bail is made out. My lord, that is the precise reason, my lord, to whatever subject to correction, my lord. In bail, my lord, I have to, whatever little I have gone through the judgment, my lord, there is no straitjacket formula, my lord. Some courts are granting bail in 1 year, 6 months. Some are granting bail in 4 years. Some are granting bail in Ravi Prakash, 3 years. There are other judgments, Chitra Biswas, this particular judgment, Amal Datta, or in all those cases, 1.5 years. Your lordship's judgment are there where 2 years, 3 months. My lord, none of those cases has been overridden, has been overturned by the Supreme Court. No, not even a single judge. Rather, 2 judgments where bail was denied. That is, one is, my lord, Anjan Datta, the other one is this, Amal Das. And this is, my lord, this is as latest as this judgment was rendered on hardly 15 days. 1/3/24. 1 month.
Okay.
And he was also a medical practitioner. He is also a medical practitioner.
At what stage the trial is pending?
Trial is only 1 witness has been examined.
Out of how many witnesses?
20 witnesses. Page 49, my lord will see. Only 1 witness has been examined, which is at page number 49. Page 49, my lord will see. This is the way how they are conducting the trial. PW1.
Yes,
Lordship, LCR received. I have tried to go through the things, but it is not in a orderly way. But yet then, I have gone through the same. Lordship, now the thing is that here, there is an agreement between Amal Das that has been already stated in the petition also. Amal Das and the present accused petitioner. They all are related to the drug dealing. Now, there is one letter from the end of Amal Das, who was right now get the privilege of bail. There it is clearly stated that through particular death agreement, he was given the responsibility. So this person, he is the main culprit.
Of what?
To doing the business. of all this medicine because of the codeine cough syrup 44,160 bottles, Lordship. And it is test positive 197.82 mg in 100 ml bottle. So that is the quantity, Lordship. And it is not on the same footing, this accused petitioner. And neither they can get the parity as because from the Tarun Kumar's case, the parity is not there. Lordship, may kindly see the LCR. I tried to flag mark some portions there. And only one witness is examined.
No, their ground are limited ground. Their ground is 1 year, 9 months prolonged incarceration. Second is he is a drug dealer. He is a licensed drug dealer with having a trade license. Third, he was the consignee.
Yes.
And the sender of the consignment was already being granted bail by the Supreme Court.
Absolutely.
So on that ground, he's
Whether I am at a higher pedestal
he
for
is
bail.
yet to receive. Where it was intercepted.
It was intercepted at Guwahati, Jorabad. Whether I am at a higher pedestal for two reasons. One, I don't have a criminal antecedent. The person who is on bail has a criminal antecedent. Though he was acquitted, my lord, it will be wrong on my part to say criminal, but there was some allegation. Then, my lord, this man at page 37, why I have indicated page 37, that is 161 statement of Amal Das, he clearly admits that he has purchased this consignment and he was sending it. So I am at a higher pedestal. And one more thing, my lord, I would like to clarify in most of the cases in NDPS Act where we rely on the ground of parity, this judgment comes up, Tarun Kumar judgment. My lord, there is a significant difference between Tarun Kumar judgment and judgments in relation to NDPS Act. Primarily because
Tarun Kumar says that on parity may not be ground for allowing, it may also not be ground for denying bail. If
my lord, Tarun Kumar is a judgment rendered at the backdrop of PMLA Act. Now, there is a significant difference between PMLA Act and NDPS Act. This is under the PMLA Act, if I make a confession before an enforcement director, it is admissible. This is admissible. Under the NDPS Act, if I make a confession under section 67, it is inadmissible. Therefore, in Tarun Kumar judgment, it was argued before the Supreme Court that the only material against him is a statement made before an ED. Then the court said no. Under the PMLA Act, this is an admissible piece of evidence. Now, that judgment is shown to oppose a bail in NDPS Act on ground of parity. Even in Tarun Kumar judgment, if I remember correctly, the Supreme Court has said that parity will not be a ground if the accusations are different. But with identical accusations, my lord, there will perhaps be no bar in granting bail. So Tarun Kumar will not come in NDPS Act because NDPS Act section 67 is barred.
Lordship, here the petitioner is not in the same footing with the Amal Das. Lordship, may kindly peruse the para 8 of the petition. Para 8 of the petition, Lordship.
My submission is that I am at a higher pedestal for grant of bail. I am not in the equal footing. I am at a higher pedestal.
Para 8.
Paragraph 8.
Yes.
Yes, Lordship, where it is clearly stated that there is a transaction from Hemtech Pharmaceuticals.
And Hemtech's owner is Amal Das.
Amal Das, Lordship.
Yes.
But there is an agreement, Lordship. That is the thing, the agreement with the petitioner. And there is a reply from the drug authority. That letter is there, where Amal Das replied to the authority of drugs.
No, we are not on the merits. Because Supreme Court was not on merit.
I will leave it to your Lordship.
I am obliged.
But Lordship, the fact is that the commercial quantity, huge contraband, 44,160 bottles. And they have reflected that there is an agreement.
You have flagged the.
Yes, I have flagged.
Okay, I'll go through it.
But when a counsel says, I leave it to your lordship, we normally we understand that probably
Not always.
Out of it, that's the understanding at the bar, my lord. I'm deeply obliged.
Heard Mr. M. Vishwas, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Let this case be listed for delivery of orders on Monday,
I'm so.
on 8th of
Deeply. obliged.
45.
Yes,
Met your lordship.
you refresh me
Lordship.
very shortly, briefly.
Here lordship, date of arrest is 26/8/2022.
26/8.
2022. As on date, 1 year, 7 months, 6 days.
Yes,
And out of 9 witnesses, 3 witnesses are examined till now.
yes.
So my first argument is that on the point of delay. And my second argument, your lordship, is if your lordship kindly turn to page 22. Page 22.
No, delay and prolonged incarceration are two different things.
That
Delay may be there in trial,
Lordship.
provided you are not in jail.
Lordship.
Your submission is on
prolonged
prolonged incarceration.
Prolonged incarceration.
Yes.
Page
Ne-
22.
Page,
Page 22.
yes,
Your lordship will find that first serial number, that is Pawan Kaur petitioner number 1, that
Oh,
is 10
in the
kg,
same magic vehicle,
4 persons.
4 persons were
Yes.
traveling.
And from me, from petitioner number 1, 20 kg was recovered. And from petitioner number 2, 18 kg was recovered.
Okay,
And
And
my
you s-
humble submission is that lordship, there is no material to show that
to connect.
there was any abatement or conspiracy between the two.
And you had cited one judgment.
Yes, lordship. That
Which-
Amar Singh Ramji Bhai, that Supreme Court citation lordship, 2005 7 SCC.
Judgment this is, yeah. Gandhi. You have copy of that judgment?
Lordship.
Amarji,
Amar Singh Ramji Bhai.
what it says?
That to attract section 29, there has to be material to show that abatement or conspiracy is there.
Para?
Para 8, lordship.
Okay.
And another judgment which I have cited, that Rosida Iqbal Khan and Sagar Nana Borkar of Bombay High Court.
What it says?
Here bail was granted considering the individual capacity recovered
That
from.
citation is,
That-
judgment will be required.
Relying on the Supreme Court judgment, that Amar Singh.
Okay. And this Sagar Nana,
Sagar Nana relied on Rosida Iqbal Khan. That similar case that recovered from him 10 kg and from another 11 kg. So individual quantity was recovered in absence of material to show abatement or conspiracy.
Yes, Mr. Boza.
My lord, that day Lordship has heard me also, Lordship. And my lord, since he has realized some decision, Lordship has asked me to, my lord, peruse all the citation he has referred to, my lord. My lord, first and foremost, Lordship, these 4 accused persons, they were apprehended together, Lordship. And the contraband, Lordship, yes, it is admittedly, it is true as per the CZD, Lordship, that they were carrying the contraband, Lordship, which were not commercial in nature, Lordship. They are all intermediate quantity. Now, Lordship, regarding section 29, Lordship, my lord, they were together and they were carrying the, my lord, same contraband. That itself is a conspiracy, Lordship, as per my humble submission, my lord. Because the contraband was the same, my lord. It's a ganja. And that is all total, my lord, 73 kg, my lord. Now, Lordship, the search has been framed, and now, as of today, 3 witnesses have been examined, Lordship. Now, regarding, Lordship, Amar Singh Ramjibhai Berot, by the state of Gujarat, Lordship. Well, in this case, this was an appeal, Lordship. It was convicted by the trial court. It was upheld by the High Court. Then, but the Honorable Supreme Court has set aside because, Lordship, the as per paragraph, my lord, paragraph 7, Lordship. 7 and 9, 7 and 8, Lordship. My lord, I am just reading the relevant portion. In our view, however, there was no warrant of this for this conclusion at all, as there is no evidence to suggest that there was any such abatement and or criminal conspiracy within the meaning of section 29 of the NDPS Act. Well, that was come after a trial, Lordship. After a trial, Lordship, the trial court hold that there was a conspiracy. High Court also upheld that there was conspiracy, but Supreme Court hold that there was no conspiracy. But in this case, Lordship, the trial is yet to commence, Lordship. Now, the other judgment, Lordship, that is Rashida Iqbal Khan, Lordship. This order is, my lord, my daughter friends also provided me a copy, Lordship. The order is cryptic, Lordship. That is, nothing can be, my lord, seen the whether it was a, my lord, case of, my lord, trial, or it was after conviction, Lordship, or it was, my lord, when the appellant was, my lord, preferred an appeal, then this order was, or judgment was passed, Lordship. This is a very cryptic order, Lordship. So I'm not making any submission, Lordship, but it is true that, Lordship, considering the, my lord, judgment of the, my lord, this Amar Singh Ramjibhai Berot, Lordship, this Rashida Iqbal Khan was also, my lord,
But
relied
it was a bail application. Pending
bail.
trial, bail was granted.
Bail was granted, Lordship. But this order, my lord, it is very cryptic order. Nothing has been mentioned, my. So my humble submission, Lordship,
That as they were traveling together,
they're carrying that contraband, my lord, that was, my lord, same contraband, Lordship.
but in different bags.
In different bag and but the quantity they have carried, it was not commercial, Lordship.
Okay.
So my lord, as per the Supreme Court observation, Lordship, that cannot be club, Lordship. That is, my lord, what the Supreme Court has, my lord, decided, my lord. And conspiracy, Lordship, at this stage, it will be very difficult to prove, Lordship.
So at this stage, some material has to be there to show that there was conspiracy. Prima facie some material. That prima facie material, according to you, is that they were
my lord,
moving together.
Yes, they were, my lord, they were going together, Lordship, and they were supposed to travel to Bihar.
Okay. Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Bova, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Pawan Kumar Yadav and Suraj Kumar, who have been detained behind the bars since 26/8/2022, within bracket 1 year, 7 months, 6 days. For last 1 year, 7 months, 6 days, bracket close. In connection with special NDPS case number 121/2021, corresponding to Bajari Sera PS case number 156/2022, under section 20 within bracket small b small Roman 2, within bracket small Roman C, small c /29 of the NDPS Act 1985. B. The gist of acquisition in this case is that on 25/8/2022, one Dibakar Gogoi, SI of Police of Kothaltoli Watch Post had lodged an FIR before officer in charge of Bajari Sera Police Station, inter alia, alleging that on 11:50 on that date, an information was received that 4 persons were traveling on a passenger magic vehicle and were carrying seven to 8 bags of ganja with them. Accordingly, on the same day, at about 12:15 p.m., the first informant arrived at Kothaltoli Bazaar Magic Stand and found 4 persons with luggage in the four persons with luggage as passenger in magic vehicle bearing registration number AS 11 AC 2925. All the 4 persons were apprehended and 8 bags belonging to them was also seized. And it was found that the accused persons, namely what was the total weight? It was found that they were carrying total 73 kgs of ganja in 15 numbers of packet. Stop. Later on the basis of the said FIR, Bajari Sera PS case number 156/22 was registered under section 20B2C/29 of the NDPS Act. And investigation was initiated. Ultimately, on completion of investigation, you have annexed the charge sheet.
Lordship.
Charge sheet was laid. Charge sheet was laid
Charge sheet, annexure 4, Lordship.
on when the charge sheet was laid.
Date is not mentioned in the charge sheet, Lordship.
Charge sheet was laid against how many accused persons?
Against 4, against 4.
Against 4 numbers of accused persons, including the present petitioners. How many witnesses are listed?
9 witnesses, Lordship.
Stop. Learned counsel for the petitioners has submitted that though the petitioners are detained behind the bars for last 1 year, 7 months and 6 days. However, until now, only 3 of the 9 listed witness have been examined. And there is unlikelihood of culmination of trial. And therefore, on the ground of prolonged incarceration, the counsel for the petitioner, learned counsel for petitioner has prayed for allowing the petitioner to go on bail. It is also submitted, next para, it is also submitted by learned counsel for the petitioner that the contraband seized from the individual capacity of the present petitioners is less than commercial quantity. And it was wrong to club the contraband which was seized individually from the petitioners together to bring it under the purview of commercial quantity. Stop. It is submitted by learned counsel for the petitioners that from perusal of the FIR itself, it would be clear that from the custody of PW1, that is Pawan Kumar Yadav, total, how much? 15 kg?
From Pawan Kumar Lordship, 20 kg.
Total 20 kg of ganja was seized, whereas from
Sanjay Kumar, 18 kg.
From Sanjay, from Sanoj
Kumar.
From Sanoj Kumar, 18 kgs of ganja was seized. Then counsel for the petitioner has submitted that as the seizure from the petitioners was made individually from their luggage, which was carried individually by the petitioners, as has been mentioned in the FIR. And as there is nothing on record to show that there was any abatement or conspiracy to bring conspiracy within the meaning of section 29 of the NDPS Act, the contraband seized from the petitioners could not have been calculated together to bring it under the purview of commercial quantity. Stop. It is submitted by learned counsel for the petitioner that if calculated individually, the total quantity of contraband seized from each of the present petitioner would be less than commercial quantity. As for being commercial quantity of ganja, it has to be more than 20 kgs, which is not the case in the instant case. In support of the submissions made by, no, before that, in support of learned counsel for the petitioner has also submitted that if the seized contraband is calculated individually, it would not be within the purview of commercial quantity, and therefore the embargo of section 37 would not be applicable in this case. In support of his submissions, learned counsel for the petitioners has cited a ruling of the apex court in the case of Amar Singh Ramji Bhai Barot versus State of Gujarat, reported in 2005, 7 SCC 550, wherein it was observed as follows. Quote paragraph number 8 from the judgment. The learned counsel for the petitioner has also cited ruling of the High Court of Bombay in the case of Rashida Iqbal Khan versus State of Maharashtra, within bracket, criminal application number 2177/2006, dated 21/6/2006, as well as another ruling of the High Court of Bombay in the case of Sagar Nana Borkar versus State of Maharashtra, within bracket, criminal bail application number 3636/2022, dated 15 September 2023. On the other hand, learned additional public prosecutor has submitted that has vehemently opposed the grant of bail to the present petitioners on the ground that all the 4 accused persons arrested in this case were found together in the magic vehicle bearing registration number AS 11 AC 2925, and all were going to Bihar from
Patharkandi, I think.
from Patharkandi, and the total quantity of ganja seized from their possession was 73 kgs, and therefore it was commercial quantity of ganja, and embargo of section 737 of the NDPS Act is applicable in this case. It is also submitted by learned counsel for the learned additional public prosecutor that mere fact that all the 8 accused persons, all the 4 accused persons, including the present petitioners, were found in the same vehicle carrying the same contraband is itself an indication that there was an abetment and criminal conspiracy between them within the meaning of section 29 of the NDPS Act, 1985. Stop. On prolonged incarceration.
Prolonged incarceration, my lord, on 11/7/2023, charges framed, lordship. Thereafter, lordship, 3 PWs were examined, lordship.
Learned counsel for the learned additional public prosecutor has
Out of 9 witnesses.
also submitted that as out of 9 witnesses, already 3 witnesses have been examined. There is likelihood of culmination of the trial very soon. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the scanned copy of the case record of scanned copy of the case record of NDPS case number of special NDPS case number 121/2021, including the case diary of Bajari Sera PS case number 156/2012. On perusal of the FIR, it appears that the seizure of contraband was made from 8 separate bags belonging to 4 accused persons, including the present petitioners. And it has been specifically mentioned in the FIR as from whose bag how much quantity of contraband was recovered. It appears that from the possession of no, how much possession from the position of Pawan Kumar?
Pawan Kumar, 20 kg.
20 or 30?
20. That your lordship will find page 22,
Yes.
serial number 1, that is each packet weighted 5 kg, total 10 kg.
Or total 10 kg.
Total
Okay,
10.
okay.
For Pawan Kumar 10 kg.
What was the last name?
And Soros Kumar 8 kg. Lord.
Okay. It appears from the FIR that from 2 bags, 2 bags of 2 bags belonging to petitioner Pawan Kumar Yadav, total 20 kg of ganja was recovered, whereas from 1 bag from
1 and 4, lordship. Pawan.
whereas from Sanoj Kumar, that is petitioner number 2, 2 bags containing 18 kgs of ganja was recovered. So it appears that at this stage, apart from the fact that the petitioners were found in the same passenger vehicle and were found to carry similar contraband, no other material could be shown to suggest that there was abatement or criminal conspiracy within the meaning of section 29 of the NDPS Act. As though the petitioners were found together in the same vehicle, however, they were found carrying the bags individually from where the contraband was recovered, and therefore, as per the judgment of the Apex Court of India in the case of Amar Singh, Ramji Bhai Barot versus State of Gujarat, within bracket Supra, it may not be possible at this stage, at least prima facie, for the purpose of consideration of the instant bail application, that there is material to show that section 29 is attracted in this case. Moreover, as the contraband found individually from the possession of the present petitioners is of less than commercial quantity, this court is of the considered opinion that embargo of section 37 would not be applicable in this case. Stop. Therefore, now further, as the petitioner has already been detained. Petitioners have already been detained behind the bars since last 1 year, 7 months, 6 days. This court is of considered opinion that they are entitled to get bail in this case. In view of above reasons, the petitioners, namely Sanoj Kumar, namely Pawan Kumar Yadav and Sanoj Kumar, are hereby allowed to go on bail of rupees 50,000 each with one surety of like amount. What would be the surety, that assurance that you would face the trial?
Any condition, I will appear. Let there be some local bail also.
With 50,000, with two sureties of like amount, and one of the surety may be a government servant. May be a government servant. You don't have difficulty. Subject to following conditions, that the above, that the petitioners shall cooperate in the remaining part of the trial and shall appear before the trial court regularly as and when so directed by the trial court without fail. The petitioners shall not directly or indirectly make any inducement, threat, or promise to any of the listed witnesses or any other person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts during the trial. The petitioner shall not indulge in any similar offense with which they are similar to that with which they are charged with in the instant case. With the above observation, this bail application is hereby disposed of.
Here is one thing I may point out, Lordship, that Sessions case number 121 of 2022. That in my cause title, Lordship, it is wrongly written as 21. And probably record is correct, Lordship, that record.
Then amendment would be required.
That your Lordship may direct, and I will file the cause title, amendment cause title.
Sessions case number 120. What is in?
Case number is correct, Lordship. That's special NDPS case 121 of 2022. Instead of 2021, it will be 23.
Wherever it is mentioned 21, special case number 121
of 2022.
2022.
Outline.
It is the Lordship. But in this case, I'm behind the bar for 601 days. And I'm taking Lordship to my FIR page 13.
No, what is your submission?
I'm behind the bar for last 601 days. That is 1 year, 7 months, 23 days, my lord. And there are
601 days.
601 days, my lord.
1 year, 7 months.
23 days as on today, my lord.
Okay.
Page 13 is the FIR, my lord. So here, my lord, an information was received from the BSF that there will be some dealing of some peddlers were loitering at the place, my lord. So they formed a team, my lord, for apprehending the.
What is your ground?
My lord, in this case, may I just read one paragraph, my lord?
Yes,
From the FIR.
we will read, but before that, I want to know on which ground you are hitting.
Nothing has been recovered from this person. He was sitting in a passenger auto, my lord, the passenger seat. And some contrabands were recovered from the backside of the passenger seat, and driver fled away, my lord. And so he was arrested. And then he was taken to custody, my lord. Charge sheet has also been filed against him. Some other persons were there. The police also arrested some other persons, but nothing against them, my lord. And thereafter, my lord, till date, not a single witness has been examined in this case. That is another ground, my lord, in the part of delay also. So FIR, Lordship, may kindly peruse page 13, my lord.
Yes.
Yes. May I read, right, my lord, from the second paragraph from bottom, my lord. We reached nearby Arman Servicing Center located at Chengju roadside, where one suspected unknown person was found sitting at the passenger seat of auto bearing registration number AS10A 0 such and such, which was parked near Arman Servicing Center. The vehicle was detained and interrogated the suspected person and recovered suspected Yaba tablets packed with white transparent plastic kept inside black color polythene bag. The polythene bag was hidden at the backside of the passenger seat. The driver of the vehicle was not found present inside the auto and known to be fled away from the spot. So that is the allegation, my lord. Based on that recovery of a packet of Yaba tablets, my lord, on the backside of a passenger seat, I was taken into custody.
This vehicle was,
It's a, 50.
okay. And later on driver was not found.
No, my lord. Later was driver, in fact, he was not even charge sheeted also in this case, my lord. And vehicle was also given to the custody of its owner, my lord. Lordship will find that in the order sheet, my lord. I have also that certified copy along with me.
The statement of driver was recorded.
No, my lord. He was not even, there was no attempt to arrest him, my lord. And
No,
probably he was,
as witness, he was not examined.
no, my lord. Nobody knows who is the driver. It could have been easily, my lord. His information could have been gathered by examining the owner, my lord, when the Jimma was given.
Yes.
So that is my lord. Although, my lord, it is very apparent, my lord, from the backside of a passenger seat, a contraband was recovered. So by merely sitting in a passenger auto, my lord, that recovery cannot be linked with this present petitioner, my lord. That cannot be termed as a conscious or constructive possession, my lord, under
At
this.
what stage the case is pending?
My lord, evidence, my lord. See, my lord, the charge sheet was dated 30/11/2022, and charges were framed on 9/10/2023, my lord. And till, my lord, till date, not a single witness has turned up, my lord. Lordship will find the records are updated, my lord. So, my lord, consider.
How many witnesses are there?
There are, my lord, seven, not exactly seven, my lord, I'll just. Exactly. 7, 8, 9, 10, 11 witnesses, my lord. Names of witnesses, Lordship will find at page 22 and 24, my lord.
Okay, what else is your submission?
My lord,
This much?
This much, my lord. This recovery cannot be linked to this present petitioner. He was just a passenger, my lord. And the person who was the driver, my lord, he fled away from the place. And no, there is nothing on record that he was apprehended, he was interrogated, or he has implicated this petitioner that, yes, that was the person who was carrying the narcotics, my lord.
No, where this packet was kept?
Yes, my lord, that kept, it was kept, my lord. May I read that line again, my lord?
Yes.
We reached nearby Arman Servicing Center located at Chengju roadside, where one suspected unknown person was found sitting at the passenger seat. The vehicle was detained and suspected person recovered suspected Yaba tablets packed with what transparent but inside black color. The polythene bag was hidden at the back side of the passenger seat, ma'am. It was recovered from a hidden part of the seat, ma'am. Another ground is that no criminal antecedent, and I'm a local person, my lord. I'll face the trial also. So with any stringent condition, it is considered, must we consider his conditional liberty, my lord, at this stage.
My lord, I'll at this stage also, I rely on the Caesar days also. As per the Caesar days, this contraband has been recovered from his possession.
No, it is, where is this result list?
So that is, my lord.
Page 15, my lord.
But in the FIR, it is mentioned that it was kept inside the.
Hidden at the backside of the
Then at the
passenger.
backside of the.
Passengers.
Yes, but my lord, the Caesar days page 17, lord, may kindly peruse.
circumstance of seizure.
Bag was concealed at the
Passenger-
backside of the passenger seat.
passenger
My lord, yes.
Now, this bag belongs to him because vehicle does not belong to him.
The vehicle does not belong to him, lordship, but my lord,
What?
as per the Caesar date, lordship, because trial has not commenced, lordship, search has been framed.
No, then you will caught hold of any person. Suppose you are traveling in a vehicle where somebody has concealed, then what defense he will take? There has to be some material to show that this material belongs to you. The driver could have been examined.
Then lordship, while preparing the Caesar list, he should have objected, lordship, because he has put his signature in the Caesar list.
No, in seizure list it is mentioned. Circumstances of the seizure, read circumstances of the seizure. That it is seized from the backside of the passenger seat. It is not from his possession, it is in the vehicle. Is there any other material? Who was the driver? No, whether identity of driver could be disclosed during.
No, there has been
No,
three
no.
accused person, lordship, there has been search sheeted, lordship, apart from the present accused person. The one Tajul Ahmed and one Asik Mia, lordship.
Who are,
So, altogether, charge has been submitted against 3 persons, lordship.
who are
including the-
these two?
My lord, they were just picked up from the road, my lord. That is, and they were not the driver and the owner, my lord. I have annexed their bail order with the learned
They are
child.
on bail.
They are on bail, madam. They were granted bail by the learned child court, madam, because there was no specific thing, because they were not driver of the.
But they are also charge sheeted.
They are also charged.
What the trial court had observed?
Trial court had observed that since I have not implicated them, my lord, and nothing is, lordship, 34, my lord. That's what, good, my lord. Thirty-five is the middle portion, my lord. 120. The materials nowhere suggest the incident accused either to have delivered the contraband article to the FIR named accused. There is nothing in the statement of the FIR named accused, either from whose possession contraband articles are suggesting the involvement of the incident accused in the alleged offence. Which persons have picked up the
Yes, Mr. Baba. Is there any other material?
No, as per my lord, from the search sheet, lordship, because my lord, charges has been framed. So search sheet, lordship, I have not found anything, my lord.
Otherwise, delay is also there.
Yes, delay part is, my lord, there.
Heard Mr.
M.A. Chaudhary.
M.A.
My
Chaudhary,
objection may be recorded, lordship.
M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Baba, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure from 1973 has been filed by the petitioner, namely Ikram Hussain, who has been detained behind the bars since 11/8/2022 within bracket for last 601 days, that is 1 year, 7 months and 23 days in connection with special NDPS case number 117/2022 corresponding to Patharkandi PS case number 203/2022 pending in the Court of London, Session Judge Karimganj. The gist of accusation is that on On which date FIR was lodged?
10,
On 10/8/2022. One. Miss.
11:30 PM they received information. AM.
Who is the informant? One
Informant is
Long Sing Kiro,
Yes,
one
ma'am.
Long Sing Crow,
Pro.
SI of police, had lodged an FIR before the officer in charge of Patharkandi Police Station, inter alia, alleging that on receipt of an information through reliable source that some narcotic drug would be transported to some unknown location through Lakhipur via Patharkandi Road, a Naka checking was conducted. At Lakhipur Road, and when the Naka checking party reached near Arman Service Center located at Chengui roadside, one unknown person within bracket the present petitioner was found sitting at passenger seat of an auto bearing registration number AS01 AS10 AC 0950, which was parked near the Arman service station. When the said vehicle was searched, it was found that on the backside of the passenger seat, one polythene bag was hidden and Yaba tablet weighing about 1 kg, 152 grams was recovered from the said packet. Who are the other two persons?
Other 3 persons, they were not.
On receipt of the said FIR, Patharkandi PS case number 203/23 was registered and investigation was initiated. On completion of the investigation, charge sheet was laid against 3 numbers of accused persons, namely the present petitioner.
Second, Tajul Ahmed, and third one is Ashik.
Where are their names?
Page 21. Lordship will find the other 2 persons' name. Page 20.
Present petitioner and other 2 persons, namely Tajul Ahmed and
Ashik.
Ashik. Stop. Learned counsel for the petitioner has submitted that the petitioner was only a passenger of the vehicle in which the seized contraband was found concealed behind the seat of passenger seat. It is also submitted by learned counsel for the petitioner that the present petitioner was not in conscious possession of the contraband which was recovered from the seized vehicle. Learned counsel for the petitioner has also submitted that during the investigation, neither the driver of the said vehicle was made as an accused nor a witness, and though the vehicle was given in custody to the owner of the said vehicle. However, owner was a witness.
No, my lord, Ahmed Hussain, Said Ahmed. No, my lord.
However, the owner has also been not made as a witness in this case. It is also submitted by learned counsel for the petitioner that though 11 numbers of witnesses have been cited in this case, and even after and charges were framed on 9th of October 2023. However, till today, not even a single witness has been examined. On the other hand, learned counsel for the petitioner has, on the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that the seizure list shows that the recovery of the contraband was made from the possession of the present petitioner. Stop. The other two have been granted bail.
Yes, I have annexed, my lord, that order.
So I have considered the submissions made by learned counsel for both the parties and have perused the materials available on record carefully. I will reason it in the chamber.
My lord,
I am allowing the petition. Conditions you.
He's a local person, my lord. So there is no chance of.
There will be certain conditions.
And my lord, one thing, my lord, the last date was fixed on 22/2/2024, my lord. Sorry, I'm sorry, my lord, 12/3/2024. So till then, lordship, no evidence was recorded. After that, lordship, we do not have any,
But that is his submission only.
Yes, that is his submission, my lord.
Till now, no evidence.
No, my lord. No, my lord. In fact, yesterday I was.
Submission may be recorded.
No,
Because I have, from the record, lordship, I'm saying, my lord.
On 12/3.
12/3, lordship, the next date was fixed.
Okay. I'll dictate it in the chamber. Prayer is allowed. Subject to 50,000 with one surety of life.
And keep your place.
May it please your lordship. Lordship 439 of CRPC and the accused are arrested on 4th of February and today 58 days in custody, your lordship. And the FIR is page number 9. It submitted that yesterday night, that is on 3/2/24, some unknown miscreants broke the shutter lock SBI ATM booth.
58 days.
Yes, lordship, we are not caught red-handed and only on suspicion to be arrested, your lordship. And we are not, our name is not mentioned in FIR.
What was the article stolen?
What's it?
What was stolen? ATM.
My lord, 38 lakhs of money, lordship. 32 lakh 30,000 300 rupees, my lord. 32 lakhs 30,000 300 as per the FIR, lordship.
From
Unknown
where it
miscreant.
was stolen?
My lord, my lord, by cutting the ATM machine, lordship, with gas cutter, lordship, they have stolen the ATM money from the ATM, lordship. That
But
is
lordship,
amounting
my
to,
name is
lordship,
not
32
mentioned in
lakhs.
Is there material against?
My lord, during investigation, lordship, they were apprehended and from their possession, lordship, this, my lord, gas cutter, then oxygen cylinder, then two, my lord, regulator, and two battery charger. These are, my lord, recovered. Which was used for, my lord, cutting the ATM machine. My lord. It is very difficult to, my lord, cut the ATM machine also. Only through this, my lord, articles they can cut, my lord. And it is recovered from the possession of these two petitioners.
No, how will you connect that this was used for cutting the ATM machine?
No, my lord, that is during investigation also, because investigation is going on.
We have stored only for our personal use, Your Lordship.
Now only 2 days are left.
My lord, that, my lord,
Incident
yes.
is committed on 3 of
One and two,
February.
lordship, 59 days, and 3 is 51 days, my lord.
3 is from Borpeta, Your Lordship, and the bail objection made by the IO, Your Lordship, on the page number 22. Only preliminary stage they have not granted to bail, Your Lordship. We have bail objection mentioned, but this is not a preliminary stage. Today, 58 days is completed.
What do you do with that cutter machine?
It's our personal usage, Your Lordship.
What
We have
personal
a
use,
tag
Lordship?
also.
No, you can explain it that you have some business. Is there any submission on that line?
No, Lordship, actually, we are not committed this offense because we have not got red-handed, and in FIR also, our name is not mentioned. Incident has been committed on 3 of February.
No, but
And
regarding
we are
the
arrested
submission,
4th of
regarding the
February.
submission that from you, gas cutter machine, gas cutter was,
We have not used for. Not suspicion to be arrested. Only length of detention, Your Lordship, there will be.
Investigation is going on, lordship.
457 IPC.
but you don't have time.
Man, that is the reason, my lord.
Apart from seizure of gas cutter, anything, what was seized?
My lord, 2 numbers of oxygen cylinder, 1 large, 1 medium also. 2 numbers of gas cylinder, 2 pipes of waves, 2 numbers of regulator, 2 number of battery charger, 2 numbers of gas cutter, 1
Why
dowel.
they were arrested? On what basis they were arrested?
Not thou, Your Lordship, one Dio.
Dio means?
Dio means, Your Lordship, perfume. They have mentioned all the things, Your Lordship. Then the
Okay.
mobile phone.
No, why they were arrested? On what basis they were arrested?
They were arrested because lordship, police was mother investigating, getting the matter lordship. Then lordship, they were stopped. They were traveling in a my lord vehicle. Then from their position, my lord, this articles were recovered.
On which day?
On some suspicion, lordship. That is my lord investigation of the police, lord.
No, when they were arrested?
My lord, Caesar was met on 4/2/2024. 4/2, lordship. 4/2/2024, lordship.
On the same day?
Same day, lordship.
No, and when the offense was committed?
3/2/24. FIR is page 9.
So
Most
next,
humbly, it is submitted that yesterday night on 3/2/24, some unknown miscreants broke the shutter lock of SBI ATM booth. And FIR was lodged and seized on 4/2/24. Incident has committed on 3/2/24.
heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. R.J. Barwal, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners Jahul Khan, Muhammad Aslam Hussain, and Maghrab Ali, who are detained behind the bars in connection with Pageford PS case number 53/2024 under section 457/380 of the Indian Penal Code, corresponding to GR case number 97/2024. The petitioner number 1 and 2 were arrested on 4/2/2024, and they have completed 59 days of detention.
As per my calculation, my lord, today will be 60 days, lordship.
60, they have completed 60 days of detention. And petitioner number 3, Maghrab Ali, was arrested on 13/2/2024 And they have completed how many days?
1 and 2, 60 days, Lordship. And my lord, 3 is 51 days.
51 days of detention. Learned, stop. The accusation in this case is that on 4/2/2024, one Santumoni Bharadwaj had lodged an FIR before the in charge of Borghat police outpost, inter alia alleging that on the night of 3/2/2024, some unknown miscreants had broken the shutter lock of SBI ATM booth at Tinimail and have stolen away a cash amount of rupees 32,30,300. Learned counsel for the petitioner has submitted that the petitioners are in no way involved in the offense which has been alleged in the FIR. It is also submitted that the petitioner number 1 and 2 have already completed maximum period of detention for which they can be detained behind the bar under section 167 of the Code of Criminal Procedure, whereas petitioner number 3 has completed 51 days of detention. Hence, considering the period of detention, she has prayed to allow the petitioners to go on bail. On the other hand, learned additional public prosecutor has submitted that from the petitioners, instruments and tools which may be used in cutting ATM machines were recovered, like oxygen cylinder, gas cylinder, regulator, etc. And investigation has not yet been completed. Stop. I have considered the submissions made by.
And this was recovered the very next day, Lordship, of the incident.
Recovered on 4/2/2024. Stop. Money has not been recovered.
No.
I have considered the submissions made by learned counsel for both the sides and have perused the materials on record. Since the instant case has been registered under section 457/380 of the Indian Penal Code, for which the maximum period of detention under section 167 of the CRPC, Code of Criminal Procedure, during which the petitioners may be detained, is 60 days only, and petitioner number 1 and 2 have already completed the said period, as well as also considering the fact that the petitioner number 3 has also been detained for a considerably long period, 51 days. His custodial detention may also be not necessary if he cooperates in the investigation. For the reasons mentioned herein above, all the above named 3 petitioners are hereby allowed to go on bail of rupees 30,000 each with.
Well, only petitioner number 1 and 2, they are from Rajasthan, Lordship. So there may be some strict conditions, otherwise they will never turn up for trial, Lordship.
What kind of conditions?
There may be some local bail, Lordship.
Okay. But apart from gas machine, you could not collect anything.
Gas cutter, then cutter pipe, then Lordship cylinder, then Lordship iron rod. These are all used for cutting the ATM machine, Lordship. And their statement also recorded, Lordship, but I am not relying on their statement. They have also, they've said that they have been brought from Rajasthan, Lordship, to do this, my lord, act. Because, my lord, it's need very expertise, Lordship. It is not easy to, my lord, cut a ATM machine, my lord.
What condition can be imposed?
Let there be some local bail or one local bail or this.
The the petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, who should be a permanent resident of Assam, state of Assam, with to the satisfaction of learned Chief Judicial Magistrate Tejpur, with following conditions, number 1 and number 2. You will cooperate with the IO. With above observation, this bail application is hereby disposed of.
Much obliged, Lord.
May it please your lordship. Lordship, this is a 439 bail application, lordship. In this case, 20 days in jail custody, lordship. FIR, lordship, will find on page 18, lordship. This petitioner is a lordship drug distributor, lordship. FIR that is on page 18, lordship. This FIR was lodged on 2/3/2024, lordship. In the FIR, this petitioner's name is not there, lordship. Two persons, Jahil Hussain and Arshad Ali, was arrested, lordship, while coming from.
Before starting my lord, in that case, there has gone through my lord, Mr. K.K. Das, my lord. There is some inquiry regarding my lord, 100 ml, 1000 ml equals 1 kg, my lord. Regarding this, my lord, he has gone through it, my lord. But due to his emergency, my lord, he has left the court, my lord. Medical emergency.
Okay.
Meta fixed for tomorrow, day after tomorrow, my lord.
You have found
Lordship, that lordship, I'm not on that lordship, whether that lordship can come under commercial quantity or not, lordship.
That is
Because lordship, commercial quantity has defined in the section 2 of the 8A, lordship. If it is if it is beyond the specified limit, lordship, then it will fall under commercial quantity, lordship. He had 1 kg, lordship. 1
no,
kg
no,
is
not 1 kg. That
Yes.
was my query.
yes,
It
lordship.
is 1
But
liter.
lordship, in the lordship schedule,
No, Mr.
lordship.
Chaudhary, listen carefully. I have put query very carefully.
Yes.
The seizure is of 10 bottles of codeine syrup,
Coding here.
and each bottle contains 100 ml.
100
So if
ml.
you calculate, it will come to 1000 ml.
Yes, lordship.
My query was 1000 ml is equal to how much kg? In kg, if you convert liters, liters is in volume,
Yes, lordship.
kg is in mass.
Yes, lordship.
If you convert liters into kg, how much does it come? Because the notification which is appended,
That is in
it is in kg.
kg.
So if it is 1 kg, then you may get bail.
Yes, lordship.
If it is more than 1 kg, even point more than 1 kg, you may not get bail.
But
So
lordship,
you
the-
were asked, what
lordship,
was
the-
the conversion of 100 ml,
Now, lordship,
1000 ml in
In-
kg? That was the query.
now usually lordship 1 kg to equivalent to
Not
it is-
usually. I need specific answer.
I said, then lordship, tomorrow lordship. Then.
Tomorrow come prepared.
Yes, lordship.
On request of learned counsel for both the parties, let this matter be listed again on 4th of April.
May it please your lordship. Lordship, this is a 439 bail application, lordship. This petitioner in jail custody for 22 days, lordship. Here, lordship, case was registered under section, lordship, 120B, 406 and 420, lordship. In all this case, lordship, the punishment is 7 years, lordship. But here, lordship, 41A notice was not issued against this petitioner's lordship. That lordship reason they have stated, lordship, prior to that, lordship, the FIR lordship will find on page 18, lordship. Now, lordship, forwarding report, lordship, That is on page 20, Lordship. May I take you the Lordship specific on para ground number 5 in page 22, Lordship. Why 41 notice was not issued, Lordship? Otherwise, Lordship, punishment is 7 years, Lordship.
Yes.
That cannot justify, Lordship, when Lordship Satyendra Kumar Antel case, Lordship, it is make and mandatory, Lordship, to issue 41 days notice, Lordship, if the punishment is 7 years, Lordship. And moreover, Lordship, here the prime accused is the Fazlul Ali, Lordship.
Even a notice may be dispensed with if the arresting authority comes to a conclusion that you are required to be arrested.
That ground
That
has to be
reasoning has to be mentioned.
But Lordship, they are kindly come to the page 22 and pay paragraph 5, Lordship.
Yes.
That is the only ground, Lordship. If the accused person is not arrested or released under section 41A CRPC notice, they may be caused the evidence disappearance may hamper with the evidence as well as they may abscond, Lordship. All these person, Lordship, they are local, Lordship, no one from outside, Lordship. They are within the jurisdiction of Lordship, North Lakhimpur Police Station, Lordship. They are the local person, Lordship. And moreover, Lordship, this petitioner has been, he is not prime accused in this case, Lordship. Fazlul Ali, Lordship, he is the mastermind, Lordship. He used some person, Lordship, regarding
Yes.
My lord, we have received the case diary, Lordship. My lord, there is a, my lord, gang of conspirator, Lordship, led by one Fazlul Ali, Lordship. My lord, what he does, Lordship, there are some member in his gang. My lord, he provided money to them to purchase a vehicle, Lordship. After that, Lordship, he takes the vehicle and he sold to one, Lordship, Prosenjit Singh, alias Jack of Hojai, Lordship. Then, Lordship, what happened? The person in whose name the vehicle was purchased, he was asked to, Lordship, lodge an FIR before a police station, stating that, Lordship, his vehicle has been, my lord, lost, and thereby, Lordship, he could not pay any, my lord, installment amount, Lordship. That is the, my lord, conspiracy of the, my lord, the gang. The headed by, Lordship, one Fazlul Ali. And in the name of petitioner, Lordship, one Bolero vehicle was purchased. Then after a few days, Lordship, it was sold. Then, Lordship, this petitioner, this person was asked to, my lord, lodge an FIR before the police station.
Now, who has lost the FIR in this case?
My lord, in this case, Lordship, probably, my lord, police has lost the FIR, my lord.
yes, police has lost the.
Where is the FIR?
That is on page 18, Lordship.
Why police lost the FIR? Why it's suspected?
No, that is, my lord, reflected, Lordship, why, my lord. With reference to the subject cited above, I have the honor to report that on 11/3/2024 at 5 p.m. an SIR received from SP office Lakhimpur through RCB number so and so and GDNT number so and so that SIR complaints Shafiqul Islam of Lakhimpur stating that on so and so on 5/3/2024 9 p.m. he purchased one Mahindra vehicle and Mahindra vehicle pickup van Vishwanath Ashok Auto Limited Town Banto, which was financed by Mahindra Finance. The complainant took Gautam Bora with him as a driver. When the sales executive Jagadish Soikia delivered the vehicle to the complainant, the alleged accused, namely Nasir Ali, Mofidul Islam, Nasir Ahmed, met the complainant at the said dealer, and the said vehicle was driven by Nasir Ali, and the three alleged accused ordered to drive the other vehicle, which was brought by Nasir Ali to Gautam Bora. Then they were discussing about taking the new vehicle to Kharupetia Sabji Market. On the way to Kharupetia at Laluk, the three accused took seat in the new vehicle, and then it reached Bandar Dewa. The three accused person attacked the complainant by iron rod and get him get him off from the vehicle. Restrain him not to inform the police at Bandardua up to 11. Also, Bandardua up to 11 at night. After that, they entered to Arunachal Pradesh Bandardua gate. The complainant also stated that when Gautam Bora tried to help the complainant, he also got beaten by the three persons, and they also took Gautam Bora with them. The complainant mentioned in the SR that for the purchasing of the vehicle, the elder sister of the complainant, namely Hafiza Begum, gave money and also told the sales executive Jagadish Soikia of Biswanath Osuk Auto LLP that she will be present at the time of delivery and requested to not give delivery to another person, but the sales executive illegally gave information to the alleged accused person by WhatsApp about the delivery, and he was also responsible for what happened next.
My
On
name
the
is
basis
not
of
there,
lordship, that information, this FIR was lost, lordship.
Amongst them, Lordship, my name is not there, Lordship.
Now, what is the submission?
No, my submission was the investigation is going on, lordship. Although my lord, several accused persons are arrested, lordship. My lord, only my lord, the person, my lord, who purchased the vehicle, lordship, from them, he is my lord, police is searching him, lordship. So that part was
When were you arrested?
Lordship, this petitioner arrested and forwarding on 13/3, Lordship. Today, 22 days, Lordship.
Okay. Give me the case now.
My lord.
I'll go to the case.
Considering the length of detention, Lordship, among them conspirator, Lordship, my name is not there, Lordship. The Fozlul Ali, who is the master.
Led by Fozrul Ali.
Yes, Lordship.
And the present petitioner.
Fozlul Ali is the, my lord, he is the
Master.
leader of the gang, lordship. When a vehicle was purchased, lordship, he financed, my lord. Suppose lordship, the vehicle was purchased
No, but
in
what
my
is
name,
the
lordship, then
allegation against Inamul?
Inamul, lordship, in the name of Inamul, the vehicle was purchased. After some time, lordship, the vehicle was sold to, my lord, this Jack, alias, my lord, Prasenjit Singh of Hojai. Then, lordship, the Inamul was asked to lodge an FIR of stolen of his vehicle, lordship. Then he lodged an FIR before the police station that his vehicle has been stolen, lordship. Actually, what they does, lordship, they sold the vehicle. Suppose the value of the vehicle is around 10 lakhs, lordship. They sold the vehicle at 5 lakhs and they lodged an FIR before the police station that their vehicle has been lost.
But in the
And
first
stolen.
part of the
So
FIR, Lordship,
under
that is
which
not there.
provision this case was registered?
My lord, under my lord,
120B, Lordship.
406,
and
420.
420, Lordship. And there is no satisfactory explanation regarding non-issuing of 41A notice, Lordship.
And regarding 41A notice?
The 41A notice was not issued, lordship. That is my lord clear from the case there, my lord.
Then they are entitled to that. Because on that ground.
That, Lordship.
Heard Mr. B. Chaudhary, London, counsel for the petition. Also heard Mr. R. J. Bora, London, additional public prosecutor. This application has under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Muhammad Inamul Ali, who has been detained behind the bars since 13/3/2024 within bracket for last 22 days in connection with North Lakhimpur PS case number 56/24 corresponding to GR case number 174/24 under section 120B/406/420 of the Indian Penal Code. The gist of accusation in this case is that the gist is what you have stated, Mr. Borua. That is
Yes, this is the mother. They are a mother group of mother conspirators headed by
gist
my
of
lord. This
accusation is that
Fozlul Ali, my lord. An investigation is pending, lordship, because there are some other accused persons yet to be arrested.
that on 12/3/2024. One, Rajiv Kolita, SI of Police, had lodged an FIR before the officer in charge of Lakhimpur Police Station. In the FIR, what is the allegation? In this FIR,
Page 18.
fourth paragraph.
The modus operandi is that, Lord Sir, they sold their own
Fourth
vehicle
page.
and lodged an information.
On page 18, Stan and James. FIR as follows. It is submitted by learned counsel for the petitioner that the petitioner is not named in the FIR. You are not named,
Not named in the FIR.
not named in the FIR, and no, and though the offense under which this case has been registered is under section 406 slash 120B slash 420 of the Indian Penal Code. The maximum punishment for all the offenses, all the aforesaid offenses is not more than 7 years. And therefore, as per the main guidelines of the apex court in Arnesh Kumar versus State of Bihar,
And latest one, Satyendra Kumar Antil versus
as well as in in
That's-
Arnesh Kumar, Satyendra Antil has reiterated the
Yes,
Arnesh-
yes, Lord. Yes,
Arnesh Kumar versus State of Bihar. The issuance of notice under section 41A of the Code of Criminal Procedure is mandatory. However, in the instant case, no such notice was issued to the present petitioner, and he has been behind the bars for last 22 days. And therefore, prayer for bail has been made. On the other hand, an additional public prosecutor has opposed the grant of bail to the present petitioner and has submitted that there is a racket involving many accused persons, and leader of the said racket is one who is the
Forzul Ali, Lord.
Forzul Ali, and the modus operandi of the said racket is to purchase vehicle
On finance, what?
on finance, bank finance, in the name of some person, and thereafter they used to sell that vehicle and and lodge false FIR regarding
They are stolen of the
regarding
vehicle.
theft of the said vehicle
Yes, ma'am.
and theft of the said vehicle. Stop. It is submitted by learned counsel that to unearth the whole racket involved in the offenses of such nature, which is committed in organized manner, the custodial interrogation of the present petitioner would be necessary. On the other hand,
No, man, he is already on bail, Lord. Sir. Malok, investigation is going on, man.
who is on bail?
No, he is already in jail, Lord. Sir.
In jail, Lord.
In jail.
Further custodial,
Yes, sir, further.
further custodial interrogation would be necessary. Stop. I have considered the submissions made by learned counsel for the parties and have perused the case diary of North Lakhimpur PS case number 24/2023. apparently, now, in this case, it appears that the petitioner has been detained behind the bars for last 22 days. And apparently, the offenses involved in this case are have punishment which is less than 7 years. And therefore, mandate of issuance of notice under section 41A of the CRPC is applicable in this case, which has not been followed in this case. In Satinder Kumar Antil versus, what is the citation?
CBI Lordship 2022-10 SCC
In Satinder
551.
Kumar Antil versus CBI reported in 10
2022 10 SCC
10 SCC
51 page.
51. The Apex Court of India has observed that what was the observation?
Observation Lordship, that is on page the Lordship's ground number Lordship 10 100 and 100.2. The investigation agency and their officials are duty bound to comply with the mandate of the section 41 and 41A of the code, and the said direction issued by this court Anesh Kumar. Any direction on their part has to be brought to the notice of the higher authority by the court following by the appropriate action. The court will have to satisfy themselves on the compliance of the section 41. Any non-compliance would entitle the accused for grant of bail.
Has observed that non-compliance of section 41A in cases where same is required would entitle the accused person to get bail on that ground only. Considering the above observation of the Apex Court, as well as considering the period of detention already undergone by the accused person, undergone by the petitioner, this court is of opinion that the petitioner is entitled to get bail in this case. Hence, the above named accused person is allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned Chief Judicial Magistrate North Lakhimpur with following conditions. Number 1 and number 2. Send back the case.
Lordship, I beg apology, Lordship. The first part of the FIR, his name is not there, Lordship. During inquiry, his name is coming, Lordship. In the second part of the FIR, Lordship. In the first part of the FIR, among the conspirator, his name is not.
Now, should I cancel the bail?
Hello.
You have to be very careful.
Yes, Lordship. On the inquiry, Lordship, it is said Inamul name is there.
I will.
Highly obliged.
The case there to be required.
Case diary returned back.
Obliged. Matter Lordship. 430 application Lordships. The silent case Lordships. It is on an interim Lordships.
430?
438 Lordships.
Charge sheet submitted.
It is on an interim Lordship.
You have appeared before the
Lordship, I have appeared Lordships.
Heard Mr. M. Hoft, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
21 of 23, dated 31/3/23.
It appears from record that by order dated 17/3/2023, the petitioner, how many petitioner are there? One.
One, my lord.
Petitioner Altab Ali Maulana alias Muhammad Altab Hussain was allowed to go on interim anticipatory bail by this court with certain conditions, and it is submitted by learned counsel for the petitioner that in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated with the investigation, Stop. in view of the laying of charge sheet and in view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 17/3/2023 is hereby made absolute with condition number 2 attached to the said order remaining intact. With above observation, this bail application is disposed of.
May I please your lordship, the dispute between the parties are civil in nature. And as per this honorable court order dated 4/1/24, the petitioner appeared before the investigating officer on 14 January 2024. And my lord, the petitioner agreed to return back the security earrings accordingly.
My lord, here we have not received the case diary. It was earlier received, my lord. Therefore, I just sent back for up to date, my lord. Then up to date CD not received, my lord.
My lord, the case is related to civil.
Whatever, maybe, my lord.
But he has appeared before the IO.
Yes, my lord.
Up to date CD, it was called for up to date CD, my lord.
Okay,
My
we
lord,
are,
the petitioner agreed to pay the security.
No, that is
gold
a different thing, but from verbal, my lord.
earrings.
no, but why CD is not there?
No, it is sent for up to date, my lord.
Okay.
Up to date CD was called for.
Interim
Mr.
order may be continued.
It was sent
Mr.
back, my lord.
What is your name?
A.K. Hannan.
Heard Mr. A.K.
Hannan.
Anand, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional for the prosecutor, who has submitted that the case diary has been sent back for updation.
My lord.
And same has not yet been received. And some time is prayed for producing an updated case diary. The prayer is allowed. Let this case be listed again on.
My lord, till date interim may be continued.
2nd of May 2024. The interim order shall continue till next day.
Hello.
Item 40.
May I please proceed? CD was called for.
CD not received, my lord.
You are on interim bail.
Interim, my lord. Interim, my lord. Last order, no? Last.
Learned, heard
Yeah, along.
A. Alam, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case. The prayer is allowed. Let this case be listed again on
2nd May.
2nd of May. The interim order shall continue till next day.
Deeply obliged.
Item 51 from supplementary list.
Lordship, case diary was called for.
Which one?
My lord, here also charge sheet submitted, my lord.
You are on interim.
No, my lord.
Oh, that sheet has been.
My lord, my lord. POCSO 4 is there, my lord.
Then you appear before the trial court.
My lord.
Heard Miss
R.R. Bora.
R.R. Bora, learned counsel.
There is a 39 attributable correction of the bail order, whether I find a miscase, my lord. Can you take it up to the?
Item number 11, prohibition.
You have not mentioned.
I have not mentioned.
You have to make mention. Otherwise, I will take it up, not in between.
Yes, your lordship.
Yes.
Lordship, my senior is out of station, so lordship kindly adjourn the matter for today.
Heard Miss, what's your name? What is your name?
Your name. Your name.
Anam,
Be loud. What is your name?
Anamika
Anamika.
Das.
Heard Miss A. Das, learned counsel for the petitioner.
Oh, sorry, your lordship.
Your name, your name. What is your name?
I have to say my senior's name.
On behalf of? You are on behalf of?
Petition.
Name? What is the name?
Heard learned counsel for the petitioner, who prays for an adjournment on the ground that her senior, who is the conducting counsel in this case, has personal difficulties today. Considering the ground the prayer is allowed, let this case be listed after a week.
Well,
Lordship, it's a 482 application. Last time the CDN ML was called for.
No, what is the method?
Lordship.
CD is there.
City.
There's a
Cancellation
private
of-
respondent also.
My lord, their attendance is also necessary, my lord. It
He's
is the
not there.
cancellation of bill, my lord.
Okay,
Inform me he's gone for iftar actually.
okay, then we'll take it up some other day.
My lord.
But Lordship, it was there.
CD is here, but respondent is necessary to hear
Yes,
the.
yes, yes, I agree.
Heard Mr. H. Kolita, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. However, as learned counsel for the private respondent is not present, let this case be listed again on, when do you want?
In a short date, Your Lordship.
After Bihu.
Then CD will have to retain till
Retain CD.
fix on.
Oh, okay, okay. Let it be on 9th.
90.
9th.
9.
Lordship.
Retain till 9th of April.
Oblige, Your Lordship.
Yes, what is
Item
your,
number 39 taken up tomorrow. my lord. Correction, my lord.
what is the method?
Later, my lord, actually, my lord, the interim order was six petitioner is there, my lord. And at the time of interim, my lord, as four petitioner was granted bail, two petitioner due to arrest. But in final order, my lord, some typographical mistake, but six was also written as arrested, my lord.
The order was passed by this
No,
court,
my lord,
some other
my
court.
lord, Justice Honorable Justice Pukor, my son.
So it should go to this,
No, man, she is already retired, my lord.
or Rumi Fupan.
Man.
Okay, okay.
Well, tomorrow, man.
Lordships, item number 44.
39.
That part heard matter from day before yesterday in admission in today's supply list. It may be kept on Monday. The part heard matter, the IA for 389 IA in an NDPS appeal.
Okay, Monday.
Great.
44
Item 44.
on Monday.
Honorable Chairman.
No, sir, I think the matter, item number 31, Lordship, but then better be taken up on 5th of April.
Okay, 5th of April.
May I plead, Your Honor? Your Honor, I beg to mention item number 32. Actually, I have already served a notice and I have received a service person receipt according to office note, Your Honor. So kindly it may be fixed on after Bihu, Your Honor. Maybe after 23rd of April, Your Honor.
Then we are not passing orders. After Bihu, registry will give date. Others, we are leaving the matters as leftover. Unless there is some urgency, only mention the urgent matters.
Yes, Your Lordship, may pass.
Otherwise, or you may take orders from,
Whatever Your Lordship may.
Item 37 will not. After maybe 19 maybe fixed.
from the court master, date from the court.
Item number 33, my lord, criminal appeal. It was listed for IA and the petitioner is in jail, my lord, for 4 months and odd. So matter may be kept on 5th, my lord. There is some urgency.
When?
My lord, item 33.
When do you
criminal
want?
appeal. 5th, my lord, day after tomorrow.
5th, we may have to rise little early.
My lord. My lord, then tomorrow, my lord.
Tomorrow we have NCP matters. And tomorrow there is a death reference.
And we'll update on 5th, my lord, if possible, my lord. let it appear in the list, man. We'll take our chances.
Okay.
Maybe little bit.
Public.
Item number 36, madam. Already listed for 3 times, so the IA is there. And the old lady is 54 years lady is in jail, conviction. But fixed before Bihu, fixed on
ninth.
Ninth.
Item 34, it may be fixed next week, Lordship. Any date next week, Lordship. Item 30.
Okay, next week. Date
My
will
lord,
be given by the-
item 38 and 14, maybe fiction Monday, date.
Monday it may be difficult.
No, then Tuesday before.
This is okay. This suspension matter is there.
Yeah,
When do you want?
Tuesday.
Okay.
Then item 40 yours, criminal petition. Item 4.
40, let it be after before.
So item number 35, I have mentioned in the morning, Lordship, there is some urgency, can it be taken up tomorrow, Lordship? The punishment is 2.5 years.
Oh,
He has
yes,
already
yes.
undergone about 4 weeks. 2 months.
Okay, tomorrow.
Tomorrow, at 2, Lordship.
At 2, we have already fixed.
Tomorrow, Lordship. I will make mention. All right.